Lord, may I be permitted to mention this matter? I am compelled to mention this matter. The writ petition is pending at the motion stage. Now, my lord, this is an order, a writ petition questioning the order of the appeal committee of the board by the council, another body corporate. Now, your losses kindly see the appeal committee's order last two paragraphs. He says that you have not yet obtained any stay, and if you can't get it by 10th, your salary will be stopped. The chairman's salary will be stopped. Well, the pendency, my lord, because of the congestion in the list. Last two paragraphs of this order by the appeal committee. So, my lord, I beseech. जयंत दादा बोलते हैं कि राहुल देव मन बोलता
Who is the petitioner here?
I will Bagel office.
Who is the petitioner?
The council, Birbhum District Primary School Council, and its chairman.
Is these matters are related to any appeal direction passed by the division bench in appeal?
No, no, no.
No, these are not the.
This is a writ petition, your losses. No division bench order is involved.
Okay.
So today we are 6th, my lord.
Tomorrow.
Much obliged. Well, this is the writ petition slip, your lords.
I have given notice to the.
Yes, yes. Much.
My lord, I may be allowed to mention a matter, my lord.
On the petitioner is Shishibu Sikkar Sahayika, and her service was terminated because of the fraudulently the Mukho Sahayika took her signature on the option form. 60 years, but she wants to continue up to 65 years. This was concealed to her that was the option form. So she came to this court, and Honorable Justice Sampath Sarkar reinstated her, but with the direction to the director to formalize her appointment, reappointment, the reinstatement within 1 month. But the director took 25 months. But she did not get that salary of 25 months. So this is the thing that
It will be listed.
To get her
So
salary.
list করো এর পেলে সবগুলো লিস্ট করো
My lord,
it will be listed
My lord,
পাল্টে দিতে বলো কাগজটা পাল্টে দিতে
Lordship has determination of Honorable Justice Dinesh Kumar Sharma for today and tomorrow. My lord, I am mentioning to extension of interim.
টুমরো
করে দিচ্ছে
দিনেশ কুমার শর্মা জাস্টিস দিনেশ কুমার শর্মা কি আজ আর কাল দুজন দেখে না দুদিন বলছেন
My lord, with Lordship's kind leave, I am mentioning to extension of interim order pertaining to Honorable Justice Sharma's list, my lord, expiring tomorrow. My lord, kindly listed tomorrow.
কালকে
my lord, may I have a lord's
My lord,
yes
my lord, similar prayer of that court, my lord.
My lord,
Motion and extension before your lordship.
motion
Criminal motion, my lord, because your lordship has having the urgent determination of that court and extension as well. He come back tomorrow, my lord, whenever it's convenient.
Kindly,
your
my
lord.
lord.
my lord, in this matter, my lord, my matter, my lord,
এটা motion কি মানে order has been passed
No,
into
but fresh matter. So it's not that there is
no
a
fresh matter no fresh.
But only difficulty is that my lord, the investigation is on, my lord. Your lordship appreciates, my lord. Your lordship will, my lord, may I just suggest one thing?
Yes
Your lordship will consider if I will just take 2 minutes in motion. If your lordship thinks there's no urgency, your lordship will push it to the regular bench, my lord. My lord, please, my lord.
if next
Just
week
after vacation, my lord.
if next week continues I will accommodate you
So, my lord, the extension can I?
extension which one is extension you just give that
My lord, I just given the extension, my lord.
কোথায় লেখা আছে এটা দেখো
My lord, I just take, my lord, I take back the motion, my lord.
দেখো ওটা কোনটা বলছে কোন ম্যাটারটা
ওইটা extension যেটা আপনি হাতে নিয়েছেন ওপরে।
my lord, may I be a lordship's kindly, my lord, to mention, my lord, for inclusion a matter, my lord, interim order of which is expiring today, my lord. My lord, on 4th, I have mentioned the matter, my lord, lordship was pleased to observe, my lord, if the regular bench would not sit today,
এটা
then,
কি
my lord, matter would be
supplementary list
included in the supplementary list today, my lord.
mention a matter of
এটা সাপ্লিমেন্টারি হবে आज के expire को जो given notice.
Yes, my lord, I have noticed, my lord.
May I be permitted to
It will appear in the supplementary list today. It will appear
My
in
lord,
the
I have also.
it will appear in the supplementary list today.
Yes, my lord.
My lord, if I may be allowed to mention a
Second half
matter.
at 2 p.m. you
No,
come.
I-
At 2 p.m. you come.
Yes, yes.
May I be permitted to mention a matter? It relates to Honorable Justice Dinesh Kumar Sharma's determination. It's a fresh motion, Your Lordship. The urgency, Your Lordship, the trial court date is tomorrow. Your Lordship, the complainant hearing has preferred an application on the trial court to stall the cross-examination, Your Lordship, which has been allowed and that has been assailed in the revisional application, Your Lordship. It has been filed prior to vacation, Your Lordship. However, it was not taken up. Fresh motion. If it-
Next we'll see.
Lordship,
If the
I-
determination continues, we'll definitely accommodate. Yes. Not now.
To mention a matter, Lordship.
mutual transfer.
Reading and according.
Lordship, may I be permitted to mention?
Lordship, if it could be taken up today, Lordship, 5 minutes, it's a very short matter, Your Lordship.
No. আচ্ছা আমাদের কিন্তু এসএসএ মেনশন করতে হচ্ছে
Lordship, may I be permitted to mention?
Also handing over plot.
Lordship, may I be permitted to mention a matter, my lord? This has already been mentioned on Monday, my lord, this week for inclusion by Mr. Sudeep Ghosh, my lord. Lordship directed Mr. Ghosh to, my lord, serve and come back, my lord. I have accordingly served and, my lord. This matter is regarding Lordship primary education, my lord. I was a headmistress in Howrah, my lord, primary school. My lord, I was put under suspension and disciplinary proceedings, my lord, ensued against me, my lord. The charges were, my lord, proved against me. I moved to appeal committee.
Okay,
Appeal committee
yes.
set aside. My lord,
notice you have given now? Notice has been given now?
Huh?
Yes.
May I permit, my lord, this is regarding,
may I permit to mention?
Yes.
my lord, I am praying for inclusion on a matter, my lord.
Look,
Last occasion, my lord.
the mentioning slips you are carrying for inclusion in the list, kindly hand over. Motion also hand over because all the records have not yet been received. So in that event, after receive of the records, all will be listed.
My lord, if I may be allowed to mention a matter, my lord.
May I permit to mention?
Yes. Just a minute, just a minute. Yes.
The council is appearing in this email.
But the family pension of the petitioner is not
My lord,
released.
I beg your forgiveness, my lord. After taking leave, I have come here, my lord, in person. But today, my matter is fixed before the Honorable Justice Dinesh Kumar Sharma, my lord. But item number 30, my lord, it's extremely urgent, my lord.
কতগুলো হ্যাঁ এরকম করলে তো মুশকিল হয় এর কে দিয়েছে
I mean, Rashid, this is gratuity.
how many are there
70, 80.
72 it takes some time না এটা দিয়ে দিন আপনি গ্র্যাচুইটি যেটা পাবেন ওটা লিস্ট করে দেবেন তাহলে আর অনেকে দিতে হবে না
The family pension.
all will be listed after the records are being received.
The council is virtually appeared. My lord, kindly appreciate him to
My lord,
allow him to mention.
Yes.
It's an inclusion as well.
Next week, not now. Yes.
Madrasa for inclusion. Madrasa. My lord, kindly give me an opportunity to write, please, my lord.
What
for
do you want?
inclusion.
What do you want?
Inclusion, my lord.
Inclusion.
Already, it is in the list today.
So let it be mentioned before the regular bench.
Okay, ma'am.
When is to appear expire? Okay. No. Okay. Yes.
I have affirmed, my lord. I have affirmed the application under the 498 because the allegation of
the husband is this, my lord. The wife is suffering from mental illness and supported by the medical documents also. Separate civil suit is pending. My client has affirmed, but the department is saying the entry, my lord, I'm sorry, I stand corrected. The entry is subject to the leave to be granted by the honorable court because the certified copy as has been obtained from the court below, my lord, that is not complete. Undertaking, my lord, may be permitted to be given by the advocate before the with the witnesses.
Leave to
statement is
file because
to
it is
file.
incomplete.
Incomplete because certified copy.
Certified copy is incomplete. You give
Formal
undertaking.
charge sheet is there, but the statement of the witnesses that is not there. So my advocate on record will give an undertaking that before the matter is taken up, I will submit.
একটা কাজ করো না, একটু ডিপার্টমেন্টে ফাইলিং এর কাছে জেনে নাও যে ওরা আন্ডারটেকিং দিয়ে ওরা লিভ দেওয়া যাবে কিনা। Ask a junior to come after some time. Just I intend to ascertain from the department whether on the basis of undertaking this can be accepted, because again you have to file a certified copy if it is incomplete.
না এন্ট্রি নাম্বার হয়নি, এন্ট্রি দেয়নি, আমি কপিটা আপনাকে দিয়ে যাচ্ছি, তবে জজ সাহেবকে দেখাবেন। হ্যাঁ দিয়ে যাচ্ছি। May I permit to mention one matter? The BC
Mr. Basu, it is of Justice Dinesh Sharma's determination.
Yes.
Oh. Yes, sir.
The BC link is there. The council is appearing.
Yes.
My lord, if I may. My lord, this is a criminal revision wherein, my lord, under section 223 of BNSS, my lord, prior to taking cognizance in a PMLA matter or a complaint case, my lord, a hearing has to be, opportunity of hearing has to be given to the petitioner. My lord, I had moved an application before the trial court wherein I sought for documents, my lord, the RUDs which come with the complaint, on the basis of which the complaint has been filed. The trial court rejects my application, says that yes, you should get a hearing, but does not permit me to take documents. This is a small issue, my lord. I have a plethora of judgments.
Regular bench next week you mentioned.
My lord, my urgency is that the matter is on Monday.
Why
Monday you mention. If this determination continues, you mention.
custody since 4th of April?
If the determination continues on Monday, you mention on Monday.
My
No.
lord.
Yes, Raghu, yes. Please, both cannot. I have decided no. On Monday I will.
Judgment is there.
On Monday I will grant you liberty to move and mention on Monday. If the regular, if the determination continue, no.
My lord, the only predicament is on Monday the cognizance will be taken.
Monday
My
on
petition will become infructuous.
nothing will happen. Chalo, Raghu.
Wait 1 minute.
Item number 1 is pension matter, lordship. The same your lordship has pleased to fix on Monday, lordship. Kindly fix it Monday, lordship.
Which matter has been fixed on Monday?
The pension matter, other pension matters.
No, I'm taking up the pension matters.
Lordship, kindly fix it Monday, lordship.
Not today. Ajay, on the prayer of learned advocate for the, where is your affidavit of service? On the prayer of learned advocate for the petitioner, affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record on the prayer of learned advocate for the petitioner. Place this matter on. Pension cover government. Soon. কথা বলি।
Please at least mention this to the. I have seen the pain Monday. My lord, item number 2, I'm for the petitioner, my lord. My lord, in this item number 2. My lord, I'm for the petitioner, my lord. My lord, this matter relates to my lord.
On behalf of the DPS.
I'm for the state lordship. Kindly take the matter on next day, any day, lordship.
My lord, kindly takes into consideration, my lord, the petition is 8.
I'm for the state lordship. We
My
have
lord,
to
the
take it-
petitioner is 88-year-old woman, my lord. She's claiming family pension, my lord, from 1993, my lord. After the death of her husband, my lord. 88 years old, my lord.
My lord, what has happened, my lord? The petitioner had approached the writ court, my lord, on a previous occasion in 2024, my lord. My lord, for grant of family pension in her name, my lord. My lord, they.
My lord,
My lord, she applied.
page 67.
My lord, I was offered a job, my lord, that was not taken by the family member, my lord. Only the wife is claiming for family pension, my lord, from 1993 after the death of her husband, my lord. My lord, kindly comes to page number 61, my lord. There is an inquiry report, my lord, where, my lord, the husband was granted. My lord.
My lord, come to page 57, my lord. Three also, lordship. Time chase.
So, my lord, I am appearing on behalf of district school council, my lord, Nodia, my lord. State is required to file a report. No, my lord, my authority and duty is limited. After my lord, retirement, everything lies up to the district inspector school and my lord, sanctioning authority.
State will file the report, lordship.
Is that pension sanctioning authority?
My lord, kindly records one thing, my lord. They have raised several objections, my lord. My lord, they have raised several objections, my lord, with regard to the DCR death cum retirement benefits copy, my lord. My lord, that is already submitted with the district inspector, my lord. My lord, kindly comes to page number 60, my lord. It is record. My lord, that has already been submitted in 2011, my lord. Yes, my lord.
No, lordship.
My lord, kindly comes to page number 60.
No, lordship. They have not complied with. Have you, lordship? 2 weeks kindly. 2 weeks, lordship. Yes, lordship.
My lord, 88-year-old woman, my mother.
Okay, they have not taken any step till 2019.
Better, my
Hearing.
Hearing, my lord.
Item number 3. I am for the petition. Lordship, I am for the petition. I am number 3. Lordship, I am led by Mr. Ashish Kumar Pal. He is not well. He has undergone surgery. I need 1 week time. He has undergone surgery, so I need 1 week time. Petitioner. Ashish Kumar Pal. Ashish Kumar Pal. Ashish Kumar Pal. And Monday. Most probably Monday. Lordship. Grateful.
My lord, one indulgence, my lord. Item number 2, my lord. Kindly fix the date, my lord. Item number 2, my lord.
But petitioner is the widow of the deceased. Her husband died on 25th of June 2025. As per government notification, her husband changed the option CPF to GPF and deposit the amount of 6,17,000. Now he claimed the arrear pension money.
Who is for the state? What is your submission?
Settle law, my lord.
Sanction. Arrear of pension from which date? Date of retirement.
Date of retirement. Date of retirement.
Petitioner is the widow.
Widow.
The family pension has been sanctioned.
Pension already started. I have cited one.
Arrear pension.
Passed by my lord Justice Raju. What was my single bench? It's a settled law. Last order.
Now the pension has been allowed from which date? So this judgment does not cover that.
One matter fixed on 10th.
Which matter?
Then shall fix the matter on 10th.
No, your sanction has been given from which date? Sanction of pension, family pension is from which date?
Well, date of retirement of the teacher.
On 30th. Where is the decision in 30th September 2019? You are carrying that judgment of 30th September 2019.
The judgment not easily just now.
This is something different, what you have given.
Then can fix the matter.
Hmm?
I have shown all the judgment.
Affidavit of service.
Video service.
Filed on behalf of the petitioner is taken on record and an advocate for the petitioner seeks accommodation. Please this matter after 2 weeks. Under the same heading. Next.
No,
After 2 weeks?
10th or 13th, my lord. Similar matter fixed, my lord.
10th?
10th
Which
or
matter?
13th.
Your matter?
No, Mr. Mitro matter. Mr. Mitro matter fixed 10th or 13th, any day.
Okay, 13th এ রাখুন।
13th,
13th.
my lord.
Lord, I am for the petitioner.
I am for the state, my lord.
Widow pension, my lord. Miller order passed to your lordship, my lord. This is my affidavit of service. The application for widow pension is pending before the TI, my lord.
Yes.
Kindly direct the TI to consider.
Where is the representation?
Yes, my lord. Page 20, my lord, P4.
The affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks for direction upon respondent to issue family pension in favor of the petitioner. Petitioner contends that her husband joined as a assistant teacher in Choto Khagda Primary School, Purbo Medinipur, and retired from service on 31st May 1995. Stop. The husband of the petitioner died on 27 June 2008. After the upon death of the, when did you make this application?
My lord,
Fourth-
P4, page
July
20,
2025.
July
On
2020.
death of her husband, the petitioner made an application on 4th July 2025 before respondent number 2. Before respondent 4, District Inspector of Schools, PE, Purbo Medinipur, for grant of family pension. However, the same is still pending. Hence this writ petition. Mr. So and so, learned advocate appearing for the petitioner, submits that the respondent number 4, District Inspector of School, Purbo Medinipur, directed to consider the representation of the petitioner for grant of family pension. Mr. So and so, learned advocate for the state, also submits that the matter be relegated to the appropriate authority for consideration of representation of the petitioner. In view of the submissions advanced on behalf of the respective parties, District Inspector, respond number 4, District Inspector is directed to consider a same থাকবে আগে একটা মামলা ওনা করেছি এই সেম রিপ্রেজেন্টেশনটা কনসিডার করে আপনি নিয়েছেন না within a period. What was the period given in the last application?
3 months.
3 months. Disposal.
Great.
এইটা শ্রীমানি বাবু
My lord, I behalf the state. Lord, I am for the petition. Lord, matter relates to an family pension of unmarried daughter.
grant of family. Where is that page number? It has been rejected or
My lord, instruction has been come.
still pending?
Still pending.
Pending.
Page 17, annex.
Affidavit of service. Yes.
My lord, instruction has been come. An income certificate not submitted.
They will consider subject to compliance of relevant documents as per requirement.
My lord, I have annexed the income certificate to the, my lord, HD.
Okay, hand it over.
Point number 4, my lord. Page 15P3 annex.
By affidavit service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for grant of family pension in favor of the petitioner. Para. The petitioner contains that the petitioner, she is the unmarried daughter.
Unmarried daughter, my lord.
She is the unmarried daughter of unmarried daughter now. Petitioner contains that her father was the assistant teacher at Ramkalua Free Primary School, post Kelomal in the district of Purvo Medinipur, and he retired from service on superannuation on 28th February 1993. Stop. The father of the petitioner expired on 10th September 2000. Stop. Mother was granted family pension.
Yes.
Yes. The mother of the petitioner expired on 25th May 2023.
My lord.
After the demise of the mother of the petitioner, she applied for getting family pension on 30th June 2025. However, no steps have been taken, hence this writ petition. Mr. So-and-so, learned advocate for the petitioner, submits that the respondent number 4, be District Inspector of School P. Purvo Medinipur, be directed to consider the representation of the petitioner dated 30th June 2025 for grant of family pension. আচ্ছা ওখানে না ফ্যাক্টের একটা জায়গায় বলুন the petitioner is the unmarried daughter, যেখানে অ্যাপ্লাই করেছে না ফর এনি ওখানে বলুন petitioner is the unmarried daughter. Learned advocate for Mr. So-and-so, learned advocate for the state respondent, submits that the petitioner has not furnished her income certificate. He files a report of furnished by respondent number 4, District Inspector of School P.E. Purvo Medinipur,
I have annexed
dated
the income certificate.
19th August 2025, which is taken on record. In view of the submissions advanced by the respective parties, similar, with 3 months. The petitioner shall submit relevant documents as per requirement if not already submitted before the authority concerned. Just if not submitted, you submit it so that it within what is the কবে 3 months করলাম. Within a period of 3 months from date of communication of this order, learned advocate for the petitioner directed to communicate this order to respond number 4, this is for necessary compliance. This was
Much of it. What time would this take?
yes.
My lord, matter relates to CPF to GPF, ADR, my lord. Petitioner was an was an head teacher, retired on 30th 11 2014, and as per the notification of 13th June, petitioner shifted from CPF to GPF. Now, my lord, as per the direction of the honorable larger bench, the petitioner claims the arrear pension from the date of retirement to the date of refund.
Okay. He is the employee. Petitioner is the employee.
No,
Was the employee.
was the
Yes.
head teacher.
Not sure, I have to take instruction.
What instruction?
It's a settled principle. I have the coordinate benches order also.
What instruction? He is not entitled to get that. The pension has been allowed from which date? From date of superannuation. Or from which date? Pension has been allowed from which date?
Date of superannuation.
No, he is receiving pension from which date?
Receiving pension.
On which date the pension was allowed?
PPO issued on 28 August 2015 and retired on 30th 11 2014.
14. So from 14 to 15 he will receive the arrear.
Yes, Lordship.
What is that order? Of 30th September?
30th September 2019 order judgment.
Yes, what is that order? You are having that?
That I have not carried, but I have carried the coordinate benches order.
Give that. What is the order passed in 8 February 2022? The court records that it covers the present writ petition. Yeah, this one. Affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks direction upon respondent numbers 3, 4, and 5 for sanctioning the arrear pension in favor of the petitioner from the date of retirement till date of sanction. The petitioner contains that he retired as head teacher from Dokhin Tanua Primary School on 30th November 2014. The petitioner, in terms of notification dated 13 June 2014, E1, has shifted from CPF to GPF, has shifted from CPF to GPF and has refunded the employer's share of contribution with interest and additional interest to the concerned Treasury Office on 17th March 2015. The petitioner has been granted pension from the date of refund. Hence, this writ petition praying for arrear of pension from date of retirement till the date of issuance of pension, sanction of pension, till the date of sanction. Para. Ms. Sudeepa Banerjee, learned advocate for the petitioner, submits that as per the decision of larger bench, give the reference of that. You have reference?
Now I
Larger bench. Ask Mr. Ghosh. Larger bench, what is the reference of that larger bench? 30th. In all the writ petitions, you are mentioning 30th September 2023 of that 19. And the judgment is not here. Give the reference at least. It is Sobhita Ray's judgment.
No, that is not. This is, my lord, কোনটা এরিয়াটা চাইছে দীপঙ্কর দত্ত জাজমেন্ট
হ্যাঁ এই যে শীতলা মণ্ডল
না না শীতলা it my lord this order 964 of 2022 this WP number has considered the larger bench judgment. The reference is there, my lord. Neither your lordship will wait, my lord, I will supply. This is, my lord, a clarification of the original larger bench Abhijit Boidya.
That is of Justice Sen.
Abhijit Boidya was passed, my lord, along with Chief Justice, Justice Dipankar Datta and Joy Malla Bagchi. But after 3 years, what happened? The state has disbursed the amount with effect from the date of deposition of the money. Now that clarification came, my lord, Honorable Justice Dipankar Datta sitting with Justice Joy Malla Bagchi and Chief. But that said that in arrear should be given. Against that order, my lord, SLP has been preferred. That SLP was dismissed in 2022. My lord, I shall give, my lord, within 10 minutes, I shall.
Okay. ওইটা তাহলে রেফারেন্স দিয়ে দেবেন, হ্যাঁ বললাম কি বললাম Ms. Sudeepa Banerjee, learned advocate for the petitioner. Bench. The petitioner is entitled to arrear pension past in course in she will provide past in such and such. The decision of the larger bench was assailed in appeal before the Honorable Supreme Court in SLP number 1398 of 2020, which has been dismissed on 5th January 2022. She seeks for direction upon the respondent number. Director of pension will disburse this.
Respondent number
3. For taking appropriate steps for disbursement of arrear of pension in terms of the decision of the larger bench. Yes, sir. What is your submission? What is your submission?
Lordship, I don't have instruction right now, Lordship.
Learned advocate for the state leaves the matter to the discretion of the court. In view of the settled propositions as laid down by the larger bench in such and such jeta oni deben, it is found that the petitioner who has retired from service on 30th November 2014 and the sanction of pension has been made on which date, madam? Pension has been pension order on 28th August 2015 is entitled to arrear pension from the date of superannuation till the date of sanction of pension. Accordingly, respondent number Director of Pension, respondent number 3, Director of Pension Provident Fund and Group Insurance and concerned Treasury Officer is directed to verify the records. And in the event it is found that the petitioner exercised option and refunded the employer's share of contribution within the time specified in the notification dated 13 June 2015, then appropriate steps shall be taken to issue a revised pension pay order revise why it will require a revised pay order?
Yes, Lordship.
It will require a revised pension pay order
Yes, Lordship.
in case of arrears.
Yes, Lordship.
Then appropriate steps shall be taken to issue a revised pension pay order in favor of the petitioner with effect from date of retirement on superannuation and to release the pension in accordance with the revised pension pay order. Such steps shall be taken within a period of, say,
What's it, 3 weeks?
within a period of 4 weeks. Date of communication, 4 weeks from date of communication of this order. Payment shall positively be released immediately upon issuance of revised pension payment order. Para, for the aforesaid purpose, the DI of schools concerned shall process the claim of arrears of pension and forward a necessary recommendation / sanction to Director DPPG expeditiously, who shall act on the basis of such recommendation / sanction. With the aforesaid direction, the petition stands disposal. Provide the number. আচ্ছা ওইখানে না এন্টাইটেলমেন্টটা ওই জায়গাটা কেটে দিন কেন 13th অগস্ট এই অপশনটা নিয়েছে কিনা দেখতে হবে নেক্সট ও ঘোষ নয় কালকে দেখলাম সন্দীপ ঘোষ ওটাও মুভ করেছিল সিনিয়র অ্যাডভোকেট সিনিয়র অ্যাডভোকেট
I am for the petition.
I am for the state, my lord. I am for the state. Same matter.
Lordship, same as
Same.
item number 7, Lordship. Petitioner was an assistant teacher.
Where is the challan?
Lordship.
Challan?
Yes, Lordship. Page number 14.
Okay. Same order.
Yes, sir.
Himani Babu? Disposed of.
Right, Lordship.
But I am.
For the state.
In both the cases, kindly provide
Yes,
the
sir.
judgment. Huh? Nine.
Service.
Hmm.
Debit board service. My lord, the matter relates to refund of overdrawal amount. My lord,
Refund of?
overdrawal amount which has been deducted after retirement of husband of the petitioner. My lord, the husband of the petitioner was an assistant teacher. My lord, he retired from service on my lord, 31st December 1992. Thereafter, PPO was issued in favor of husband of the petitioner.
Refund the petitioner.
Page 10.
Refund the overdrawn amount with interest.
Page 10 PPO. PPO was issued on my lord 11th March 2022. But from the PPO, my lord, 2002. But from the PPO, your lordship, if your lordship kindly come to right side of the PPO, column 7A.
7A, yes.
7A. There 7A 4. Overdrawal in pay and etc. Pay etc. 1,04,936 was deducted from the PPO from after retirement of husband of the petitioner on the ground of overdrawal of pay due to wrong fixation.
Yes.
Well, I am wanting refund of said amount. My lord, I am relying on order of coordinated bench.
দেখি হ্যাঁ
Your order din. Following the order of the Honorable Supreme Court in the case of State of Punjab versus Rafiq Musi, it has been held that after retirement, no amount should be deducted from the employee, from the ex-employee on the ground of overdrawal, etc. From page 3 of the order or judgment, Your Lordship, page 3, the case of State of Punjab versus Rafiq Musi has been cited here, paragraph 8 in the relevant paragraph. Wherein, Your Lordship, in column 2, it has been held that recovery from the retired employee or the employees who are due to retire within 1 year of the order of recovery, and number 3, recovery from the employees when the excess payment has been made for a period in excess of 5 years, and 4, my lord, recovery in cases where an employee has wrongfully been required to discharge duties. Any other that could advance the conclusion the recovery is made.
He retired as a,
My lord,
he retired from service as
assistant teacher
assistant
in
teacher,
1992,
class 3, class 4.
31st December 1992.
Those were
And the deduction has been made from the PPO, that is on, my lord, 11th March 2002, that is after retirement.
When did he retire?
Retired, my lord, 31st December 1992. Paragraph 5, it has been stated. Paragraph 5 of the writ petition.
From 1992. Yes.
I have no objection, my lord. He is entitled to it, my lord.
Then why did you deduct it? Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner contains that her husband was an assistant teacher in Salikona Primary School, District Bankura. The petitioner's husband retired on 31st December 1992. The husband of the petitioner sanctioned the petition monthly pension. Was granted monthly pension with effect from 1st January 1993. On 23rd June 2023, the husband of the petitioner expired. The respondent number 2, Director of Pension, Provident Fund and Group Insurance, Government of West Bengal, issued pension payment order in favor of husband of the petitioner on 11th March 2002. এটা বললাম না যে he was granted pension, হ্যাঁ হ্যাঁ পিপিও ওটা বলুন পেমেন্ট অর্ডার ইস্যুড হলো with effect from 1st January 1993. ওটাকে এটার পরে দিন পেনশন অর্ডারটি ইস্যু হচ্ছে with effect from this 1st January 1993. The authority concerned has deducted overdrawal in pay of rupees 104936
That was
being
deducted
agreed
from
by such action of
pensionary benefits of the husband of petitioner.
from the pensionary benefits of the husband, petitioner's husband. Being agreed by such action, the petitioner has filed the present writ petition. আচ্ছা ওখানে ওপরের দিকে নিন by the present writ petition the petitioner seeks for a refund of the overdrawal together with interest. Mr. Swansol, an advocate for the petitioner, submits that as per the proposition laid down by Honorable Supreme Court, submits not. Mr. Swansol, an advocate for the petitioner, relying on the decision of Honorable Supreme Court, passed in State of Punjab and others versus Rafiq Masi, within bracket whitewasher and others, reported in 2015 volume 4 SCC 334, submits that after retirement, the authority concerned, it is impermissible in law to deduct overdrawal from the pensionary benefits. He seeks for appropriate direction upon respondent number 2, Director of Pension Provident Fund such and such, for releasing the overdrawal together with interest. He relies on the decision of a coordinate bench of this court passed in Rama Chatterjee versus State of West Bengal and others. WPA 18422 of 2025. Para. Learned advocate for the learned advocate for the state, Mr. So and so, learned advocate for the state leaves the matter to the discretion of the court. No, does not raise any objection. Does not raise any objection. Para. The service pension and death cum retiring gratuity at annexure P2 shows that an amount of rupees 104936 has been deducted as overdrawal in payment, etc. At this stage, it will be appropriate to reproduce the para 18 quote reproduce the relevant paragraph 18 in Rafik Masi Supra as here under. Take a page a minute. The judgment is. In light of the proposition laid down by Honorable Apex Court in Rafik Masik Supra and the decision of coordinate bench in Rama Chatterjee Supra, this court is of the view that the petitioner is entitled to a refund of the overdrawal amount. Para. Accordingly, respondent number 2
and 4, your lordship.
2 and
Treasury officer.
Respondent number 2, Director of Pension Provident Fund and Group Insurance, Government of West Bengal, as also the concerned respondent number 4, Treasury Officer Vishnupur,
Bakura,
are accordingly directed to release the amount of rupees 104936 to the petitioner together with interest at the rate of 8% per annum with effect from date of issuance of pension payment order within a period of 8 weeks from date of communication of this order. Learned advocate for the petitioner is directed to communicate this order to respondent number 2 and 4 for necessary compliance. With the aforesaid direction, the writ petition stands disposed of.
Item number 10, my lord, I am for the petitioner. My lord, yesterday, my lord, last occasion, your lordship has asked me, my lord, to division bench order. Kindly, my lord, keep the charge. One is Promila Behara, that is widow, and another is Mukti Mohipal, whereas the teacher is the petitioner. Now, this case, my lord, relates to, my lord, interest. Petitioner is paying interest for delayed payment of pensionary benefit for interest of the arrear family pension of unmarried daughter. My lord, here, my lord, what happened? Petitioner husband, my lord, death was before promulgation of the act, that is 1981. My lord, PPO was issued and earlier writ petition was moved, and in terms of the order of this court, PPO has been issued in the year 2025. Now, my lord, I am entitled to get the interest on the arrear pension, not from the date of retirement, but from 15 June 1990. 1990. My lord, why, my lord, I am placing all those circulars. My lord, here is the affidavit of service and my lord, coordinate bench, earlier coordinate bench order.
Who is appearing for the state?
My lord, I have served. These are usual matters, if you lordship. Interested now.
You will appear.
No, I'm not in this.
He's
But
in the
then-
panel. He's in the panel. Now, my lord, I shall. Why, my lord, 15 June 1990, my lord, I am placing. Yeah, my lord, I have made a compilation. If your lordship kindly have a look. আরেকটা দেবে compilation? একটাই দিয়েছে? This is the 15 June circular where the, my lord, scheme has been amended and entitled to get those who died or retired before 1981. Kindly have a look. 15 June 1990. That is why, my lord, coordinate bench directed to
Okay. No, this consequential order has also been affected in respect of family pension.
family pension also.
Family pension also.
Also, my lord, it amended the scheme itself. Governor has pleased to, my lord, decide to amend the scheme with effect from 15 June 1990. Now, my lord, I have handed over the coordinate bank judgment, my lord, and this order particularly, my lord, granted interest from 15 June 1990. এই affidavit of services সঙ্গে যেটা দিলাম দেখুন, my lord, I have corrected the dates. Do not. পরের দুটো
And the 2010 notification,
my lord, with the-
1st November
yes,
2010.
I am giving, my lord. All these circulars are there. 1st November 2010.
Yes.
No, no, no. 17, page 17. এটা একটু দিন। কি? পরেরটা? কি আগেরটা? ও।
You just find out who is for the state.
Well,
Any
these are
instruction will be required.
difficult. These are usual matters appearing under the heading, but I don't know who is appearing. Well, your lordship kindly, my lord, dispose it up, my lord, appointing anybody, my lord.
Here also.
Stated হয়ে আছেন তো?
I can appoint anybody from the state
Yes,
panel.
yes, he is appearing, my lord. My other friend also there.
Oh. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondents to disburse the interest amount towards the pensionary benefits,
কি তোমার নামটা ফোন নাম্বারটা লিখে দাও
including arrear family pension, till the date of actual disbursement of the amount, together with interest at the rate of 18% per annum. The petitioner contends that her husband was an assistant teacher in Fulboni Special Primary School under Kontai East Circle in district of Purbo Medinipur. The husband of the petitioner died in harness on 7th December 1963. The petitioner is the widow of the deceased employee. আচ্ছা উনার হাজবেন্ডের নামটা husband, petitioner's husband, namely Anadi Kumar Maiti. The pension payment order was issued on 9th April 2025. The petitioner approached the concerned authority for payment of interest on the delayed payment of pension. Since no steps were taken by the authority concerned, the petitioner is constrained to file the present writ petition praying for interest on delayed payment of pensionary benefit. Mr. Saurabh Mitro, learned advocate appearing for the petitioner, submits that as per the notification dated 15 June 1990, followed by the notification dated 1st November 2010, the petitioner is entitled to interest on the arrear amount,
এরিয়া পেনশন
entitled to
এরিয়া ফ্যামিলি পেনশন
interest on arrear family pension together with interest he seeks for appropriate direction upon which authority it will be?
the treasury officer
Upon the
respondent number 4
Treasury Officer Kontai to take appropriate steps for disbursement of the arrear, disbursement of interest amount towards the pensionary benefits, including arrear family pension. Learned advocate, none appears on behalf of the state. Mr. So-and-so, learned advocate, who usually appears on behalf of the state, is requested to appear in this matter. Let the appointment of Mr. So-and-so be regularized by the concerned authority. Learned advocate for the petition is directed to hand over a copy of the writ petition along with its annexures to Mr. So-and-so, learned advocate for the state. Mr. So-and-so, learned advocate for the state, leaves the matter to the discretion of the court. It is settled proposition of law that in the event of delay in releasing of pensionary benefits to a retired employee or to the legal heir of a deceased employee, certain amount of interest would be paid to compensate for the delay in releasing the benefits. If there is delay, interest at a reasonable rate is payable by way of compensation. This is not punitive but purely compensatory. Did you make any application? No.
No, my lord, the pension payment order has been issued, page 10.
No, any application was filed before the authority for grant of interest on
Verbally, my lord, they never gave it.
in the present case, the petitioner could not apprise regarding the date of application for family pension. In view of the above, the respondent number 4, Treasury Officer Kantai, is directed to pay to the petitioner interest. They will calculate the area or area as
No, everything has been paid without interest. Page 10.
Is directed to pay interest at the rate of 8% per annum on the amount released in favor of the petitioner by way of pensionary benefits on and from 15 June 1990 till the date of issuance of payment order. With the aforesaid direction, the writ petition is disposed of. No order as to cost. Since no affidavit has been called for, the allegations made in the writ petition deemed to be not admitted.
Your lordship, my lord, kindly direct the respondent number 4.
4, Treasury Officer.
My lord.
4.
Great.
Mr. Mitra, kindly provide the notifications.
This I have to make a photocopy and then I. Item number 11, my lord, I am for the petitioner. This is also interest, my lord, for the widow daughter. My lord, area pension of the widow daughter. The pension payment order is also issued. My lord, although the facts are slightly different. Here, my lord, the father of the petitioner, my lord, who retired 15 July 1979 and died in the year 1994. Now, petitioner mother was receiving family pension, but she expired on 1998 and petitioner husband expired in the year 1996. Now, petitioner is only entitled to get on and from 10th January 2008 because 10th January 2008, government has introduced that widow daughter is entitled to get family pension. I applied for family pension and now in page 10, my lord, in 16th April 2025, government has issued the pension payment order, my lord, in favor of the petitioner without any interest. Now, I am only paying interest, but the difference would be here, my lord, interest should be calculation from 10th January 2008. because that is the government
The
circular.
date on which she was made entitled to.
Yes. And when it corrected the facts, dates, if it is, my lord, a coordinate bank's order is also there. There. এই সার্কুলারটা
আচ্ছা, স্টেট অ্যাফিডেভিট সার্ভিস স্টেটে কেউ অ্যাপিয়ার করছে না? Is there anybody from the panel, state panel? Please come. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner
তোমার নামটা লিখে দিও
seeks for disbursement, seeks direction upon the respondent authorities to disburse the interest amount towards arrear pension from the date of entitlement till the date of actual payment, along with interest at the rate of 18% per annum. The petitioner contends that her father, namely, what is the name of the father?
my lord, giving, my lord, late Bhuvan Chandra Maiti, page 10, my lord, the PPO, your lordship will.
Bhuvan Chandra Maiti was an assistant teacher in Krishnolal Chowk FP Primary School under Kontai East Circle in the district of Purbo Mednipur, who retired on 15 July 1979
Change করবে না, কি আছে, প্রথম
and
আমরা-
died on 6th June 1994. The mother of the petitioner, she was receiving family pension,
He was received family.
who was receiving family pension expired on 31st December 1998. The husband of the petitioner expired on 2nd July 1996. The petitioner is the widowed daughter of the deceased employee, namely Bhuvan Chandra Maiti. Pension payment order has been issued in favor of the petitioner on 16th April 2025.
পরেরটা কি?
Since no interest was paid on the arrears have been paid,
My lord,
arrears of payment.
everything has been paid.
Since no interest on the pensionary benefits, including arrear amounts, were disbursed, the petitioner is constrained to file the present writ petition. Para. Mr. Saurav Mitro, learned advocate for the petitioner, submits that by dint of a circular dated 10th January 2008, the petitioner, being the widowed daughter, is entitled to receive pensionary benefits. And as such, the petitioner seeks for interest on pensionary benefits and arrear amount from such date. None appears on behalf of the state. Ms. So and so, learned advocate who yes,
Lipika Chatterjee.
Lipika Chatterjee, learned advocate who usually appears on যেটা থাকে, regularize. Petitioner is directed to hand over a copy of the writ petition along with the annexures to Ms. Chatterjee, learned advocate for the state. Here also the treasury officer will be.
Yes. Respondent number 3.
3. It have to do from the date which 10 January 2008. ওই নন্দী বাবুকে অমিতাভ বাবুকে লাস্ট পোর্শনটা দেওয়া আছে ডিরেকশনটা, শুধু ডেটটা পাল্টে দেবে, উইথ এফেক্ট ফ্রম 10th January 2008
Grateful.
till which date? Till actual payment?
Till the date of actual disbursement of them.
Till the date of actual disbursement. ওখানে পেমেন্ট পেনশন অর্ডার আছে, এখানে হচ্ছে অ্যাকচুয়াল ডিসবার্সমেন্ট,
Mine.
এইটুকু শুধু ডিসপোজড অফ।
Grateful, my lord. এটা না তার উচিত হবে না, এটা নট টু টেক। আইটেম 12 আপনি আছেন? দিস ইজ মাই লর্ড অর্ডারটাও আছে।
And for the street.
This is, my lord, an overdrawn amount petitioner was asked to refund. Item number 10, your lordship has passed an order, but here the facts is little different. Here, my lord, what happened? In page 17, my lord, just on the verge of the retirement, petitioner was asked to deposit the amount, an amount of rupees 45,000. He has been done to above. My lord, I am praying only to refund the amount in terms of Rafiq Musi's judgment, para 18. Judgment of Rafiq Musi's judgment, my lord, your lordship. Kindly keep this also. This is certain matters. Para 18. I'm praying only that 45,000 should be paid. Your lordship has decided on paper.
When was he about to retire and when was this claim
Yes.
raised?
My lord, I am retired on, my lord. So, my lord, here, my lord,
Died in harness.
died in harness. Died in harness, husband died in harness on 9th June 2022.
22.
9th May 2022.
Okay.
And refund was made on
24.
10th, 1st February 2024. Page 17, your lordship will find.
But then how Rakesh Masi will come in your aid?
After 3 years of the death of my husband, my lord, this amount was deducted, and my lord, then the pension payment order issued on page 18. My lord, the Rafiq Musi is total squarely applicable. This point has been considered. Because because of the, my lord, fixation.
Made from the employee will be executed harsh and arbitrary.
Clause 2, clause Roman 2, Rafiq Musi. Para 18.
Recovery retired or the employee who had due to. But then he is neither the retired employee or the employee is due to retire. He has died in harness.
Yes. After 3 years, my lord, after the death of my husband, employer-employee relationship is over. But they cannot deduct. This honorable court already decided the issue. My lord, I have handed over, my lord, a coordinate bench judgment, my lord. Also, relying on Rafiq Musi, my lord.
Ashwin? Yes, madam.
This point already decided by the honorable Supreme.
Okay.
Date of return was 2023. The date of birth is 1963.
Any of the legal years have been given compassionate appointment?
No.
So
Only
the widow is the petitioner.
Petitioner got everything. Page 18, petitioner got everything. Only this amount, my lord, which has been deducted, he is one. Only 45,000.
Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner contains that her husband was an assistant teacher in Telugu Vidyapitham Primary School, Nimpura, Paschim Medinipur, and died in harness on 9th May 2022. Family pension when allowed?
My lord, page 17, my lord. Petitioner, my lord, deposited the amount on 1st February 2024, almost 3 years after the date of death of the husband.
After depositing the overdrawal, family pension
Family
PPO has
pension
been
started.
okay. That is on 11th July 2024, para 9.
11th July 2024, pension payment order issued.
On 11th July 2024, pension payment order was issued upon deposit of the overdrawn amount of rupees 45012. আচ্ছা, ওটা by the present writ petition বলা হয়নি না? By the present writ petition, the petitioner seeks for refund of the overdrawn amount of rupees 45012 together with interest at the rate of 18% per annum. No, it will not be from the date of death.
My lord,
The interest will be from the date you have deposited till actual payment.
yes, that would be, my lord, the coordinate bank has directed from the
From the date of death till date of actual disbursement. Carry factor holo, Mr. Ajay, hence this writ petition for withdrawal of the, for refund of the overdrawal amount. Mr. Saurabh Mitro, learned advocate for the petitioner, submits that relying on the decision of Honorable Supreme Court passed in State of Punjab and others versus Rafiq Masi within bracket whitewasher and others reported in 2015 volume 4 SCC 334 submits that the authority concerned ought not to have deducted the amount of rupees 45012 while granting family pension in favor of the petitioner. He also relies on the decision of a coordinate bench in Mausam Yara Begum versus State of West Bengal and others, WPA 30186 of 2024. In light of his aforesaid submissions, he prays for refund of the aforesaid amount together with interest. Learned advocate, Ms. So-and-so, learned advocate for the state leaves the matter to the discretion of the court. So the amount change হবে. What is that item number?
item
একটা দিয়ে দিয়েছে শ্রীমানি বাবু নিয়েছে মনে হয়।
9. Item number 9.
9. Who will issue this?
The Treasury Officer, my lord. Respondent number 3. Treasury Officer, Kharagpur.
In view of the above, respondent number 3, Treasury Officer, Kharagpur, is directed to refund the amount of rupees 45,012 together with interest at the rate of 8% per annum from the date of deposit of the said amount till the actual disbursement of the amount.
Kindly mention, my lord, 1st February 2024.
Date of deposit যেটা বললাম 1st February 24.
24.
With the aforesaid direction, the writ petition stands disposed of.
My lord, there is a same kind of judgment in 2022 Supreme Court also. Your lordship kindly keep this.
Okay.
Well, when your lordship, my lord, Rafiq Musi also, my lord, kindly.
ওটা রফিক মাসি আর এটাও দিয়ে দিন।
Same line of judgment.
এটা হচ্ছে থমাস ড্যানিয়েল ভার্সেস স্টেট অফ কেরালা, ওনার যে সাবমিশনে এটাও দিয়ে দিন। Reported in 2022 Live Law SC 438. Which paragraph, sir?
My lord, the penultimate paragraph, but I cannot remember.
Oh, 13. 13 Raskes Masi.
18, my lord. They are also 18.
18.
Sir, এটা কোনটা দিলি? হ্যাঁ, এটাই তো।
13.
Yes, yes. At 18 and
It has relied on Rafiq Masi and past 15 is the
Yes, yes.
we are of the view that attempt to recover
yes.
their increments after 10 years of his age unjustified.
Yes.
এটাও rely করছে ঠিক আছে okay
Grateful. 10, item 10. So your lordship, item 9, your lordship has passed on.
আচ্ছা 9টা নিয়েছে শ্রীমানি বাবু নিয়েছে মনে হয় দেখে নেবেন ওই জায়গাটা ডিরেকশনের জায়গাটা সেম হবে শুধু এখানে শুধু ডেট অফ ডিপোজিট থেকে টিল ডিসবার্সমেন্ট
Item 13, my lord, same as item 10, 381.
For the state.
Here, my lord, legal hair has come. Son has come for paying interest. And petitioner is paying interest on 15 June 1990.
Why 15 June?
If you issued on, my lord, 11 July 2016. Page 10. It'll last.
Interest.
Died in harness on 12 January 2080. That is before promulgation of the Act. So, my lord,
Okay.
that date will be changed.
So from date of issuance of the PPO.
From 15 June 1990 to till the issuance of PPO. Item number 10, my lord, same order. Only the date will be changed.
Okay.
Died in harness on 12 January 2020. Father of the petitioner. And PPO issued on 11th July 2016.
So interest will be from the
15 June 1990.
15 June.
Yes.
Fifteenth or 5th. It will be 15th or 5th June.
15 June. 15 June, my lord. Here is the 15 June.
Ashu. Yes, sir.
And run for the state.
Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner contains that the by the present writ petition, the petitioner seeks direction upon the respondent authorities to disburse the interest amount towards pensionary benefits, including arrear family pension, till the date of actual disbursement of amount together with interest at the rate of 18% per annum. The petitioner contains that his father was an assistant teacher in Jarighati Primary School, Dhumsai, District Jhargram, and died in harness on 12 January 1980. Stop. The petitioner's mother died on 31st January 2013. The petitioner is the only legal heir of the deceased teacher. The petitioner approached the concerned authority for payment of interest on delayed payment of pension. Stop. However, since no steps have been taken, the petitioner seeks for appropriate direction upon the respondent authorities for disbursement of the interest on delayed payment of pensionary benefits. Para Mr. Saurabh Mitro, learned advocate for the petitioner, submits that the arrears and all has been paid. Arrears have been paid.
Yes.
The petitioner is entitled to receive interest on delayed payment of pensionary benefits. He relies on the circular dated 15 June 1990. Learned advocate for the state leaves the matter to the discretion of the court. In view of the above, the respond number 4, Treasury officer is directed to pay
Respond number 3, my lord.
3. Treasury officer, which place? Kontai? Jhargram is directed to disburse, disburse to the petitioner interest at the rate of 8% per annum on the amount released in favor of the petitioner by way of pensionary benefit on and from 15th June
Pensionary
1990.
benefit including arrear family pension.
Amount released including family pension.
Arrear family.
Arrear family pension. On and from 15 June 1990 till the date of issuance of pension payment order. With the aforesaid direction, the writ petition stands being number such and then disposed of. Baki to or since no affidavit is called for, the allegations made in the writ petition is deemed to be not admitted. Give a memorandum, copy of the memorandum in this writ.
Entire, my lord, entire I am giving, my lord.
Okay.
That will, my lord, pre-81 cases. my
In
lord.
other cases also. Thank you so much.
Great.
I'm for the state.
Like, initially, my prayer was like, for disbursement of my pension. I retired from service like, on 30th September last year. Like, the pension is yet to be released. There is a circular that immediately after my retirement, the next month they have to release pension. Otherwise, penal action will be taken. That is that circular I have annexed. But immediately after service of this writ petition, I have been served with a letter on 15th August 2025. That some certain amount has been withdrawn by me. That's why they are not releasing pension. Now, this is a pure question of law. And Supreme Court has decided that after retirement, you cannot say this. Now, if you allow me to file a supplementary to bring on record this, that prayer can be more in that occasion.
Only on that ground or there are other grounds also?
That is only ground one I have seen. If you kindly look. आज कुछ नहीं तो but kindly take some after 2-3 page basically this was the option they have given the second objection. First objection they have said option exercise of option dates, but I think that has nothing to do with my case.
Okay. Affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks for disbursement of pension and all other retiral benefits to the petitioner forthwith. Mr. Samim Ahmed Learned advocate for the petitioner submits that during the pendency of the writ petition, pendency. After filing of the writ petition, a letter has been issued to the petitioner disclosing that there has been overdrawn amount of rupees 94062, which has to be refunded for issuance of the pension payment order. He further submits that it is a settled proposition of law that after retirement such amount cannot be refunded to the authority, or the authority cannot claim for refund of the said amount. He seeks leave to file supplementary affidavit for bringing on records the relevant facts. Leave granted. Let such supplementary affidavit be filed within a week with advance copy within a week. Advance copy be served upon learned advocate for the state. List this matter after 1 week.
But there is a report on the part of the
report filed by the state. You give a copy.
Let me have a copy.
The report filed by the state is taken on record. Coming week পরের week একটা ডেট দিও তো coming week পরের week.
I believe it will retain its position.
God, we are going serially. You don't. Your matter will be taken. File the supplementary affidavit. 15. Petitioner.
I am for the petitioner.
I'm for that.
Widow is claiming to refund her husband's share along with interest lordship.
Okay.
Already lordship.
Or to avail the family pension, benefit of family pension. Can be allowed?
I have the instruction.
What is the instruction?
Epidemic road service.
When required 2007.
So is there any legal bar to deposit that amount to have a family pension?
So far as to be frank enough, in terms of the judgment of the division bench, 2 division benches, 1 single bench, clarified the issues. So I leave it to lordship regarding law point discussion. Already decided twice. One, Justice Mantha's division bench, clarifying the family pension, whether the widow is entitled upon refund, in whose cases prior to date of notification of 2013 notification. 14 notification.
Okay. Now the widow is now entitled to pension.
As an officer of the court, since the court has clarified the issues, irrespective of the statute, so I leave it to lordship regarding that. Because at that point of time, the concerned teacher died. Therefore, he had no option to file the option from in terms of the 2014 circular. So in those cases, whether being the wife, legally married wife, can be deprived of that issue of getting family pension upon making payment of refund.
So let her refund the amount if she is willing to refund that amount and avail the benefit.
That is, that is legal point. Kindly seize those judgments. She has annexed. I'm thankful to her. Kindly come to page 22. Death certificate of the husband.
And if the judgment is passed, then why the authority is not following that? Every time they have to come.
And if the authorities itself decide the issue, then we are nowhere there. And first judgment kindly sees page 46. In terms of the Abhijit Poitro, it was discussed. The judgment of justice.
That is sense division. Now, next page 60.
60.
60. This is the judgment of Honorable Single Bench following earlier division bench in two matters. Shefali Jana of Justice Sen and Promila Behra of Justice Mantha Jha. Hmm? 42, na? 42. Yes. Correct. Page 42 of Division Bench Justice Mantha. Page 46 onwards, Justice Sen's Division Bench. Then again, Mantha sitting singly, taking two judgments of the earlier Division Bench at page 6.
We allow her prayer.
I leave it. I must be candid to your lordship regarding legal point. And one can note that the husband of the petitioner expired prior to date of notification as well as the judgment of the three judges bench of Abhijit Bhatta.
But even if option is not given, then also
Yes.
the family pension,
But at that point of time,
there was no chance,
not
no
have any
opportunity to avail that option.
they did not have any opportunity to make such option form because notification comes 2014 in terms of the Abhijit Bhatta. So that is the legal point issue.
Now, after the judgment of the division bench, now it is no more res integra that whether the option has been
Although
exercised
your
or not.
lordship being the single bench, always binding upon the revision bench and subsequent coordinate bench.
তাহলে similar order করে দিন।
So can you record all these submission of mine?
আসুন।
And one more point, delay point also urged by the in those judgment paragraph 10 at page 1 of kindly sees
37 years delay.
64, delay in preferring the writ petition of during this period. So it was taken, but it was not discussed in that subsequent judgment. That is also one of the point is there, but it was urged. Even then judgment was passed. Page 64. Paragraph 9 and 10.
No, but this has been discussed. Discussed in paragraph 15.
Yes.
In the backdrop of above, it cannot be said that there was delay of 37 years of filing option. The said delay cannot stand in the way of permitting the petitioner to exercise option afresh in terms of Abhijit Boiddo decision.
Just now I have argued that at that point of time,
Now, this option is that she will be granted, permitted to refund that government share.
Along with the interest, Lordship, as per notification 13 June 2014.
Notification interest refund along with interest. That is true. But she could not entitled to get interest.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks to.
If you kindly take paragraph 16, page 66. Vital point discussed and decided. The claim of the petitioner in the instance case all the more strengthened by the submission made by the state that if the petitioner's husband were alive on the date of notification, then option was there, he could. Husband of the petitioner could. But
he has expired earlier to the notified.
Chance to. In mandatory order of paragraph 7. I leave it to Lordship, subject to correction.
Seeks to refund seeks permission to refund the deposit করো seeks to deposit the employer's share of CPF amount with interest and additional interest on behalf of her husband to avail the benefit of family pension. The petitioner contends that her husband, namely husband's name, late Onkar Nath Laha, was assistant teacher at Mandaria Bhavamohi Converted Junior Basic Primary School, District Howrah. Joined করে দিন তো petitioner husband joined to the post of district পশ্চিম মেদিনীপুর
Sorry, Lordship, Howrah, Howrah. Lordship, sorry, tendering apology, so Howrah district.
তো বলতে পারবে
District Howrah.
On 7th April 1962, and after rendering service for more than 33 years, he retired from service on 31st January 2000 at the age of 60 years. The petitioner's husband exercised the option under ROPA 1990 and ROPA 1998. Died বললাম কবে? The husband of the petitioner died on 12th September 2007. The petitioner seeks permission to deposit the deposit the employer's share of CPF amount with interest and additional interest to avail the benefit of family pension. Ms. So learned advocate for the petitioner seeks specific direction. Learned advocate for the state submits that such in light of the proposition laid down by Honorable Division Bench in FMA 864 of 2022, Promila Behara versus State of West Bengal. Which was the earlier one? Promila Behara and
FMA 620, sorry, 620 Lordship.
Page number.
Page number 42.
And FMA 620 of 2018, State of West Bengal others versus Sefali Jana and others. The petitioner may be permitted to deposit employee's share together with interest and length. In view of the above, এটা করা আছে আগের এতে direction. This direction will be upon which authority?
My submission may be recorded regarding DIS report.
Or report
paragraph, yes, otherwise I shall be in a suit.
A report filed by the state is taken on record. But
discuss that in terms of that notification, petitioner is not entitled. That should be recorded.
Which notification?
This is the notification. 13th
June.
Yes. column 5, Roman 5. Copy
The
and close.
learned advocate for the state submits that only the employee can exercise option for reverting from CPF to GPF as per GO number 749 ACL SL 5S 56 dated 13 June 2014. আপনি ডিরেকশন দিয়ে দিন। She will deposit this amount before which authority?
DI Lordship.
DI will calculate the amount of and
And Lordship also before the DI Lordship. She will deposit. DI here Lordship respond number 4.
as expeditiously as possible, and this pension, if found she is entitled to, will be from the date of superannuation. It will be
Yes, Lordship.
Of the employee costs.
অর্ডারটা করা আছে, আপনি নিয়েছেন না? Disposed of.
Much obliged, Lordship.
Thank you.
Lordship, I for the petition.
Should be in the record.
Report.
The document report should be kept in the record.
Here, petitioner himself is a teacher, Lordship, paying to refund the amount, Lordship. Lordship, I am relied upon Lordship.
He has retired.
We are Lordship.
He has retired.
Yeah.
So what is your prayer?
Refund the amount that getting paid.
Disburse pension on the arrears interest period dist in the actual disbursement. Refund of which amount?
Yes, Lordship. Employer shared along with interest, Lordship.
Similar prayer.
Similar
Now he is the petitioner.
decided, Lordship. That judgment I have annexed, Lordship. Page 38.
Paragraph. Which paragraph?
Come to the page 45, para 10. Petitioner exercise option also under open 90, and automatically he is entitled to get pension upon refund of the employer share with interest, Lordship. Larger bag already decided, and thereafter, Lordship, this judgment in the 2023. Relying upon this judgment, Lordship, coordinated bench pass order, Lordship. May I hand it over? Order of Justice Rajorshi Bharat.
You have exercised your option under ROPA 9090.
টাইমটার জন্য ওনারা একবার বলি টাইমটা 2025 ওনারা দিয়ে দিন
Yes.
My lord, this is an instruction from the DI, my lord. And right now the school is under, my lord, district primary school Jhargram, my lord. Before that it was under Paschim Mednipur, but right now it is under Jhargram, my lord. And my lord, they have not allowed the pension because, my lord, they have applied the petitioner has applied on my 13/3/2025 for the for conversion from CPF to GPF, my lord. This is the instruction on behalf of the DI. That's why they are not allowing this.
No, as per the decision in Muktimoi Pal, is the petitioner entitled to have conversion from CPF?
Here, my lord, they told that this is beyond the notification 19 days from the date of this
Forget about
notification.
what they are saying. They are saying as per the notification. Now, this has been considered by the division bench. And what is the division bench order observation in the said order?
So, lordship,
Are they entitled to or not? Is he entitled
they
to
are entitled.
have his conversion?
Yes, ma'am. Then they are entitled, my lord.
Which paragraph you are indicating?
Paragraph 12.
Come to para 6, page 43, para 6. Page 43 of the writ petition, paragraph number 6, Mr. So-and-so, learned counsel, appearing on behalf of the appellants, has submitted that notwithstanding judgment of the special bench, there is a requirement to exercise a fresh option in stipulated time. And the writ petitioner having not exercised the option, sir, page 43.
43.
Have you got it?
This one is page 43, my lord.
43?
43, para.
43, page 6, paragraph 6. It says that such argument was advanced that he did not exercise the option within the stipulated period, hence not entitled to such benefits. The court says that we plainly reject the said submission as the law is clear on this point as settled by full bench Abhijit Boiddo. Now your report says that it has to be exercised within 90 days. As per Abhijit Boiddo, now the stipulation within 90 days goes because court has rejected that. After this judgment, is the petitioner entitled to refund the amount and avail the benefit of pension?
It is allowed, my lord.
Huh?
As per judgment, my lord, it is allowed to create.
Affidavit service. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks to refund to deposit the government share of contributory provident fund with interest and additional interest to avail the benefit of pension. The petitioner contains that he joined as assistant teacher in Khanamura Primary School on 15 September 1970, and after rendering 33 years of service, retired on superannuation on 31st May 2007. The petitioner exercised the option under ROPA 1990 as well as ROPA 1998. Shilo service. The petitioner seeks to refund the government share of the provident fund together with interest and additional interest to avail the benefit of pension. Ms. So and so, learned advocate for the petitioner, submits that the petitioner, since has exercised option to come under ROPA 1990 and ROPA 1998, in terms of the judgment dated 26 July 2023, passed by the Honorable Division Bench in State of West Bengal and others versus Mukti Pal, within bracket they and others, in MAT 146 of 2019. The petitioner need not exercise a phrase option, but to get benefit of pension is obliged to refund the government share of contribution in his provident fund account. Learned advocate for the state, Mr. So and so, learned advocate for the state, submits that the switch over from CPF come GPF option as per the GO number 749-AC dated 13 June 2014 has to be made within 90 days. Therefore, the petitioner has not exercised such option within the stipulation. And as such, the petitioner is not eligible to get pension. The aforesaid aspect has been turned down by the Honorable Division Bench in Mukti Pal De Supra. In view of the above, District Inspector respond number such and such, directed to calculate the amount. তারপরে এখানে যা আছে ডিসপোজড অফ
Also same, Lordship. I am putting
Same. This is
16.
same as
16.
he is also petitioner is the employee.
Yes. Yes, Lordship. Covered by the
Look for the same order.
Their Lordship, distinct sort of Howrah Lordship, secondary education.
This is
Distinct sort of Howrah secondary education. Madrasa, TI. Madrasa.
madrasa.
There is the madrasa school and TI is secondary education Howrah. Rupa?
Secondary education. Madrasa primary. Para teacher. Yeah. Teacher. High madrasa. But then this court has determination to
Yes, Lordship. Yes,
how?
Yes, Lordship. Madrasa. Madrasa. Lordship has the
Madrasa primary is there. What a madrasa? High madrasa?
High madrasa. Madrasa. Primary and madrasa.
Need to find out for determination of not today. Just let us ascertain from the department.
Then my lord, kindly fix it on Monday, my lord.
I'm not passing any order. Let it come up tomorrow.
Not this week, then my lord.
Let it come up. Chalo, Monday to list go. Not this week. Monday.
You oblige, my lord. 89 for the chart.
Yes.
Lordship. Her Lordship, the son is the petitioner Lordship. Mother was the employee and refunded the amount.
Mother has refunded the amount.
Yes, Lordship.
Family pension was
Getting pension Lordship from the date of refund. Here Lordship, son is claim the area pension of his Lordship mother from the date of retirement to till the date of refund. Lordship. Coordinated bench also passed the order Lordship. May I submit?
mother was getting the pension. Retired on it. Oh,
Return Lordship 38th April 2009.
pension was
The amount Lordship 1st September 2014.
no pension was allowed from which date?
From 1st September 2014.
14.
Yes, Lordship. Now claim is Lordship from the date of retirement to till the date of refund Lordship. That is the 1st May 2009 to Lordship 31st August 2014. Which has been decided by the special bench Lordship.
Where is the judgment? Judgment? Mhm.
Even that.
The judgment passed on 30th September 2019. This judgment, 30th September 20, list of dates.
The Lordship, order correction of the Obijit Buddha judgment, Lordship. Date of correction of the order of Obijit Buddha, Lordship.
Where is that order?
Directed to pay the amount to the retired teacher, Lordship.
No,
from
the
date of
order
retirement.
which you have referred to
Yes,
is
Lordship.
the petitioner is the petitioner is the daughter.
The son, Lordship.
The order of the coordinate bench. The wife applied for that.
Yes, Lordship.
Here is a son.
Here is son, Lordship.
Son will be entitled to receive that.
Son is the nominee in the PPO, Lordship.
Nominee.
Yes, Lordship. Come to the PPO and only one legally as Lordship. That is the page P2, Lordship.
Chirshendu Mitro. Yes.
Yes, Lordship. Shandu Mitra.
Okay. এটা রাখুন আসি পরে করে দেবো ফিরে আসি after the recess you are for the state after the recess madam yes sir.
My matter is extremely urgent and today it is fixed today before Justice Dinesh Kumar Sharma as item number 30, my lord. And my lord, I'm being a teacher. I have taken leave from the school and I have appeared, but court is not present.
So
Today,
you are
my lord.
appearing in person. There is no advocate for you. You have not appointed any advocate.
My lord,
You have not appointed any advocate on your behalf.
my lord, because my advocates are being threatened, my lord, and certified copies are also.
Who is conducting advocate in the High Court?
My lord,
জিজ্ঞেস করুন তো কে advocate কে আছে
I am appearing in person, my lord.
in person.
In person, my lord.
So mention it before the regular bench on 10th. If he joins on 10th, then you mention that.
But kindly allow me here before your.
No, sir. Mention it. Chalo.
Thank you.
My lord, I am appearing for the petitioner, my lord.
Which was this?
Mr. Order is expiring today, my lord. I am filing affidavit of service. Well, I have communicated, my lord.
Plan কিছু ফাইল করেন? You are for the state?
Miss Amita Gaur is appearing. On a leg.
Learned advocate, Mr. Swansol, learned advocate for the petitioner. The CRAN has been filed.
No,
Any-
lord, within time, my lord.
Seeks for
Within time.
extension of the interim order granted earlier on 21st August 2025.
Copy of
According
the
to law.
petition was served. Yes.
পূজা ভ্যাকেশনের 2 সপ্তাহ পেরিয়ে গেছে? না না, আচ্ছা কাল অব্দি আছে। In view of the above submissions, the interim order granted earlier on 21st August 2025 is extended till the till 1 week after the winter vacation. Let the matter appear before the regular bench having determination after 2 weeks.
Actually, I'm for the petition.
Son is the only nominee.
Son is the only one.
In which paragraph have you stated that he is the only legal heir?
From the PPO, it is clearly.
PPO.
And it's a T2 lordship.
Pension was sanctioned on which date?
Pardon, lordship.
Pension sanctioned on which date?
No, issued on 22nd May 2015.
27th May.
22nd May 2015, the pension payment order issued.
Paragraph number?
You issued that the annexed P2 lordship. And then
And her date of retirement is?
30th April 2009.
9. Ashu. Affidavit of service. Yes. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for direction upon responding authorities to disburse the area of pension Your prayer is wrong. Prayer A is wrong. Is he entitled to monthly pension? You have asked for grant of monthly pension?
Monthly pension, area pension, Lordship.
In prayer A, why did you ask for grant of monthly pension to the petitioner? Only is entitled to area pension of his mother
Yes, Lordship.
from the date of superannuation till the
Date of payment.
sanction of the pension. By the present writ petition, the petitioner seeks for disbursement of the area pension from the date of superannuation of his mother to the date of sanction of pension. The petitioner contends that his mother was a teacher of Mokhali number 1 primary school, post GIP colony district Howrah, under Jogacha circle, and she retired on 30th April 2009. The mother of the petitioner died on 7th January 2020. The pension has been sanctioned to the mother of the petitioner on 22nd May 2015. The petitioner prays for arrear pension from date of superannuation, that is 30th April 2009, till the date of sanction of pension, that is 22nd May 2015. The mother of the petitioner opted for this switch over from CPF to GPF.
Yes, Lordship.
The mother of the petitioner exercised her option to switch over from CPF to all these have been done.
ROPA 90, they have opted for. So, really,
And the deposit has also been made.
yes, Lordship. Annexure P2, Lordship.
Annexure
Chalan. Page 25, Lordship, Treasury Chalan.
25. Okay. Miss, কি বললাম? Area of pension. Since the same has not been disbursed, hence this writ petition. ওই আগেরটা ওটা বলে দিন যে hence this writ petition. Miss Shobita Khutia, within bracket Bhuiya, learned advocate for. Huh? What is your name?
My name is Orpita Shah.
Shobita Shah.
Shobita Kutia is my leader, Lordship. I am she is the advocate.
No, what is your name?
Orpita Shah.
Miss Orpita Saha, learned advocate for the petitioner, submits that the mother of the petitioner exercised her option to switch over from CPF to GPF, and she has also refunded the employer's share of contribution with interest and additional interest on on 1st September 2014. Thereafter, on 22nd May 2015, pension has been sanctioned in favor of the mother of the petitioner. The petitioner, being the nominee, is entitled to the arrear pension from the date of superannuation of his mother to the date of sanction of pension. Learned advocate for Ms. So-and-so, learned advocate for the state leaves the matter to the discretion of the court. In view of the above, the director is respond number, director of pension, provident fund and group insurance, and respondent number. That 3 and 5 which principal officer Howrah 1. Is directed to verify the records, and in the event it is found that the petitioner's mother exercised option and refunded the employer's share of contribution within the time specified in notification 75-AC within bracket L/SL/5 capital S-56/13 within bracket part PT5 Roman 5 dated 13 June 2014, then appropriate steps shall be taken to issue a revised pension pay order in favor of the mother with effect from the date of retirement on superannuation of the petitioner's mother. And to release the pension in accordance with revised pension payment order. Such steps shall be taken within a period of 8 weeks from date of communication of this order. Payment shall positively be released immediately upon issuance of revised payment pay order. Next para. For the aforesaid purpose, the District Inspector of Schools Response number 4. P. Howrah shall process the claim of arrears of pension and forward a necessary recommendation / sanction to the response number 3, Director of Pension, Provident Fund and Group Insurance, Government of West Bengal, expeditiously, who in turn shall act on the basis of such recommendation / sanction. Learned advocate for the petitioner is directed to communicate this order to respondent number 3 and 5, 3, 4 and 5. With the aforesaid direction, the writ petition being number WPA 19347 of 2025 stands disposed of.
There, mother of the petitioner already deposited the amount. The challan is there. I have annexed the challan, Lordship. She has already deposited.
Let them verify the records and thereafter they will do it. What is the difference? Right.
My lord, I am going to petition my daughter family pension, my lord. This is my affidavit of service.
Where is your representation?
Yes, ma'am. Page 21, my lord, annexure P6.
Is the
Annexure P6.
the petitioner is the
Petitioner is a widow daughter.
widowed daughter.
Yes, ma'am.
Affidavit of service file. You are for the state.
Yes, my lord. My lord, in this matter, my lord, kindly see, my lord, the teacher died on 13th May 1984. And after his death, his wife received the family pension and she died on 25th 12 2016. At that point of time, my lord, this daughter, she was married. And after the death of mother, family pension holder, she became widow after 8 years and made a representation for getting the family pension as widow daughter after 8 years of mother's death.
Is she entitled to have family pension?
My lord, in spite of that, my lord, the DI concerned also requested the petitioner to submit some documents. This is the instruction for considering the matter. Can you see, my lord?
Let it go to him. Let him consider.
Yes.
But she not yet submitted any documents. This is the instruction.
Affidavit of service filed on behalf of the petition is taken on record. Para, by the present writ petition, the petitioner seeks for
clause 6 of the instruction.
6, direction upon the respondent authorities to disburse family pension in favor of the petitioner being a widowed daughter. The petitioner contains that her father, Janmenjay Sahu, was assistant teacher, was an assistant teacher in Gopal Chowk Ucho Primary School under Holdia Circle, District Purbo Medinipur. The father of the petitioner, sorry, pension was sanctioned in favor of the father of the petitioner on 17th December 1994. When did the father retire?
That got instruction number 13/10/1977.
77.
Yes, ma'am.
After 20 years.
Died on 84th.
No, in paragraph 6 you say that is the father submitted already pension sanction. In para 6 in 1994 it was granted in his favor. Pension was granted in favor of the father of the petitioner when?
Next is P1, P21.
Page 16.
This is in favor of the mother. During his lifetime, the father did not receive any pension.
Died on 1884, ma'am.
77 he retired, he died on 84. After retirement in 77 he did not get any pension. No.
Mother of the petitioner getting.
She was granted pension.
Yes, ma'am.
কি বললাম?
It is not
No,
clear.
no. কেটে দাও। না। ওর কেটে দিন। The father of the petitioner superannuated on 13th October 1977 and died on 19th May 1984. Family pension was granted in favor of the mother of the petitioner on 17th December 1994. The mother of the petitioner died on 25th December 2016. The husband of the petitioner upon the death of husband of the petitioner on 18th April 2023, the petitioner made a representation before the respondent number
4, ma'am.
4, District Inspector of School, Primary Education, Maniktola Tamluk, Purbo Medinipur, for grant of family pension. Date to bolo 30th June 2025. On 30th June 2025. However, since no steps have been taken by the authority concerned, the petitioner has preferred the present rate petition. Mr. So-and-so, learned advocate appearing for the petitioner, submits that the matter may be relegated to respondent number 4, District Inspector of Schools, Primary Education, Purbo Medinipur, to consider.
Steps were taken, my lord. Steps were taken before writ petition filed.
To consider the representation of the petitioner for grant of family pension. 30th June 20. On the contrary, learned advocate for the state submitted that
Clause 6.
Upon submission of representation by the petitioner, she has been directed by the District Inspector of Schools on 16 September 2025 to submit legal yearship certificate and non-drawal certificate.
My lord,
Non-drawal certificate.
second page of the instruction, that was the letter submitted to the petitioner requesting, that is 18 July 25,
And submit 18 July.
before the petition happened.
And when 13 ঠিক ওটা 16 September on 18 July 2025 to submit duplicate service book within bracket না ওটা কেটে দিন ওটার আগে একটা ডুপ্লিকেট সার্ভিস বুক দিন within bracket xerox copy comma number 1 or 2 duplicate number 1 number 2 legal year certificate from district magistrate and number 3 non-sanctioned / non-drawal certificate of any kind of family pension in any other scheme. It 18 July 2025 later. Non-drawal certificate of any kind of family pension in any other scheme. The petitioner has not furnished the required documents as yet. At this stage, learned advocate for the petitioner submits that the petitioner he will comply the requirement,
Yes, my lord. All the annexes.
is ready and willing to
all the documents
produce
will be
required documents, required no, relevant documents.
Only one is service book is old service book. That's why that is not available.
Old service book is not available. Service book available with you?
I am to take instruction, my lord.
কি বললাম? We need to produce all relevant documents. In view of the submissions advanced on behalf of the respective parties, respondent number district inspector. Who will consider the respondent 4 district inspector of schools?
4.
Purbo Medinipur is directed to consider and dispose of the representation of the petitioner dated 30th June 2025 within a period of 3 months. 3 months.
Yes.
In earlier orders, 3 months have been 3 months from date of communication of this order. Petitioner is directed to produce relevant documents, if any, before the concerned authority. With the aforesaid direction, the writ petition being number W1360 disposed of.
Except my lord service book. Service book is not.
But how they will process it?
Also the yearship certificate, whatever may be required.
Available, man.
Produce the yearship certificate.
Yes, man. Income certificate, yearship certificate is here.
No, not from
produce
the
that.
DM is concerned. Yearship certificate, not from the DM is concerned, is supplied. That would all the required documents be supplied and matter will be considered 3 months thereafter.
Subject to এটা বলুন 3 months বললাম যেটা subject to furnishing of documents by the petitioner.
Right.
Not gone into the merits ওগুলো দেবেন না. Not gone into the merits ওগুলো দেবেন না. So since affidavit. Yes. একটু দেখে করবেন.
And for the petitioner, matters relating CPF to GPF area pension. My similar order passed by body bank.
Is this petitioner?
Petitioner is a legal years of business teacher. Father is an assistant teacher of primary school.
Hmm.
ঠিক আছে, তাহলে স্যারের ক্লায়েন্টরা বেঁচে যাবে। তার আগে ফাইল করি আমি দিচ্ছি।
Hmm. Who is the nominee in the PPO? Who is the nominee?
Initially, PPO has been issued in favor of petitioner's father. This is teacher. This is teacher. Thereafter,
Renuka. Renuka is the mother.
Thereafter, mother
I,
Mother has died.
but mother's
2023 November.
just a minute, Lordship. Mother of petitioner filed a writ petition for sanctioning arrear in the date of returnment to date of refund. In page number
Your Lordship's query was who is the nominee? My lord, the deceased teacher. If your Lordship kindly come to page 19 of the writ petition, annexure P1, which was the PPO issued for the time being.
Renuka is the
my lord,
wife.
Renuka Das was the name, the wife of the deceased teacher, the mother of the petitioners. Subsequently, my lord, the claim was made after the death of the deceased teacher regarding the after conversion from the CPF to GPF regarding the pensionary benefits. Likely, my lord, the case was filed and the order was passed. Now, if your lordship kindly come to the page number 26, just some days before the order was passed, the mother of the petitioners had died. Subsequently, the page number 27, the district magistrate and collector, the legal heirship certificate which was fetched, and for these reasons, my lord, the writ petition again filed with the same claim. For disbursing the
When
arrears
did the
of
mother
petition.
die?
Mother died, my lord. If your lordship kindly come to page
25th
26.
November.
Date
25th
of date,
November
25th November
2023.
2023.
An order has been passed in December
Yes,
2023.
my lord. You are unaware at that point of time, my lord, that the petitioner has been died.
So again, you have filed a writ petition.
Yes, my lord, the legal heirs who filed this writ petition regarding that claim, my lord.
Go back to the court which passed the order.
Yes, my lord.
Because you have filed a writ petition.
Yes, my
On the date when the writ petition was moved on behalf of the petitioners, he was no more in this world. This was not brought to the notice of the court.
Yes, my lord. We are also unaware of the same. Subsequently, we came to know when they
So this should be
informed
brought
us.
to the notice of the court which passed the order.
My lord, subsequently, as that writ petition, automatically the order has got no validity due to the demise of the, my
Whether
lord.
the order is valid or not, it should be brought to the notice of the court since you moved the application without being aware of the fact that the petition on date when you moved the application has expired. And you have got an order in your favor.
Yes, but my lord, the order was passed on 13th December 2023 and just before, some days before.
15th November.
December.
Okay, the petition was filed prior to that.
Writ petition was filed prior. Some days before. Yes, ma'am.
Go back to the
petition was
court which
filed-
passed the order. Think that by mistake or inadvertence this has not been placed before the court. Let the court decide. And you seek leave to substitute yourself in the writ petition. Why should that order be there? This should be brought to the notice of the court which has passed the order.
When the writ was filed, when the writ was filed.
Sir, when the writ was filed, she was alive. Now she has died, he has moved the application. Then
No communication was made.
no.
But the now the after her death, well,
Withdraw this writ petition, mention before the court that this has happened. Let
that order
had
no.
suppose this suppose for the sake of this has been disposed of. If in a pending matter, if somebody dies, you file an application for substitution bringing in the legal years on record in the same writ petition. This could have been done.
That has been
But
the matter has been
you were not
disposed of,
aware.
that order has become
No.
ineffective.
You take appropriate steps. This is not that you will file one after the other writ petition.
But in the disposal application, disposed applications, nobody can make an application for substitution or the matter has been disposed of. Legal heirs has right, the accrued after the demise of.
What will you do?
Yes, sir.
My lord, the writ petition was disposed of.
Then what happened? Disposed of. Thereafter, you been aware of the fact. Did you bring it to the notice of the court?
Just few days after the order.
After disposal, nothing remains.
No, my lord, that is not. I am submitting.
Then
I'm submitting, my lord, that as already the district
Take it,
magistrate
Dr.
already
Gurdi.
communicated.
Will you
the
withdraw this
legally
writ
as
petition, go back to the original court which passed the order? Or if you want to pursue this, I have to record this and dismiss the writ petition. Because after you became aware of the fact that this has been moved on behalf of a dead person, you have not brought it to the notice of the court. You got the opportunity, you filed a writ petition, again a writ petition. And the court has passed a direction upon the authority on behalf of the petitioner.
চিঠি দিয়েছি চিঠিটা দেয়নি
চিঠিটা দেয়নি ডাইরেক্ট ডিস্ট্রিক্ট ম্যাজিস্ট্রেট জানানোর পরে
What is the direction?
No, ওরা একটা subsequently after this order, I can produce the authority intimated that the order can be modified that in favor of the legal heirs. That can't be because the writ petition was disposed of. That is why legally after the obtaining legal heir certificate they filed a writ petition. It is the appropriate forum. Otherwise, they cannot take any steps before the order passed before the single bench dispose of writ petition.
You seek modification of the order.
Yes, my lord.
Pass.
You seek modification of the order.
You also pass a fresh order. Otherwise,
No fresh order, sir. Sorry.
This order in the name of the dead persons cannot affect
This cannot also give the right to the legal heirs to file a separate writ petition when a particular order is existence.
No, that order cannot be exist because the dead person.
The order is in existence, sir. It has not been set aside by any appellate court. On this ground that she is still alive. On the basis of that, you didn't brought it to the notice of the court. Court has gone into pass an order. Now you say that she has expired.
That can be because
If it is not communicated when you came to this knowledge that she has expired, why this was not brought to the notice of the court which was the order?
Only 2 days before. That is why
No.
communication has been made. Their mother, after all, their mother.
Will you withdraw the writ petition or dismiss the writ petition? You exercise your right. Go back to the court. The court has passed the order. At that time, the petitioner was not alive. This has not been recorded.
That is, kindly allow me to withdraw the writ petition with liberty to take appropriate steps. Otherwise, this application করুন এই অর্ডারটা
এই অর্ডারটা স্পেসিফিক্যালি বলে দিন
This is second round of litigation. In the earlier writ petition, an order was passed on. The earlier writ petition being WPA 22805 of 2023 was disposed of on 13th December 2023. Earlier writ petition filed by mother of the petitioners, Renuka Das. However, it is submitted for the submission. However, during the pendency of the writ petition, prior to passing of the order, the petitioner expired on 25th November 2023. Since such fact of death of the petitioner was not within the knowledge of the learned advocate on record for the petitioner, the same could not be brought to the notice of the court, and the earlier writ petition was disposed of accordingly. In such backdrop, learned advocate for the petition seeks to withdraw this writ petition with liberty to file, with liberty to take appropriate steps. In view of such submissions, the writ petition being number WPA 19385 or 2025 is dismissed as withdrawn with liberty to take appropriate steps. Affidavit of service filed on behalf of the petitioner taken on record.
Yes, sir. But I'm
Refund the government, sir, my lord, now he gave the reassessment from date of retirement.
Affidavit of service.
আছে তো লেখা
দিয়েছে
কোনটাতে লিখবে
affidavit of service এটা oh yes, filed on behalf of the petition is taken on record by the present writ petition. The petitioner seeks or seeks direction upon respondent numbers 3, 4 and 5 to sanction arrear of pension in favor of the petitioner from the date of retirement till the date of sanction. The petitioner contains that he has retired as assistant teacher from Ordhogram Primary School, post Ordhogram, district Bankura, on and from 31st October 2013. In response to notification being number 749 dash ACL within bracket LSL 5S dash 56 slash 13 part 5 dated 13 June 2014, the petitioner applied for conversion and deposited the entire amount of government share of CPF, including accrued interest plus additional interest, to the concerned Treasury Office on 8 September 2014. Pension was sanctioned on which date? Pension sanctioned on which date? Which date?
8 September 2014.
8 September. 8 September he deposited the amount. When was the pension sanction?
That date was started.
It is a pension. It is 4th November 2015. Column number 8 September. Okay. Sanctioned on 4th November 2015 with effect from 8 September 2014. The petitioner, in such backdrop, the petitioner seeks for disbursement of arrear pension. Learned advocate for the petitioner submits that the petitioner, the petitioner is entitled to pension from the date of his superannuation on 31st October 2013. However, the pension has been given effect from 8 September 2014. As such, the petitioner is entitled to arrear pension from the date of retirement till the date of sanction. Now, it will be 8 September 2014 or it will be 4th November 2015.
New pension plan.
In view of the above, the learned advocate for the state leaves the matter to the discretion of the court. In view of the above, the the respondent number, director is respondent number. Director, respondent number 3, Director of Pension, Provident Fund and Group Insurance, Government of West Bengal. And respondent number 5, Treasury Officer, Bankura. The director verify records and in the event it is found, same order. আর যদি ওই for the aforesaid purpose, District Inspector of Schools এই প্যারাগ্রাফটা দিয়ে দেবেন for recommendation. District consultants shall process the claim for arrears of pension and forward a necessary recommendation/sanction to the Director, Provident Fund and Group Insurance expeditiously, who in turn shall act on the basis of such recommendation/sanction. With the aforesaid direction, the writ petition being number such and such stands disposed of. কি অর্ডার সবাই থেকে তো চেঞ্জ নেই, কোনো চেঞ্জ হচ্ছে না, একই তো অর্ডার।
এই যে
Who is for the state? State appoint for them. Anybody from the panel? State panel? So you are there? You will appear in this case?
Yes, yes.
No. Same order, শুধু ওনার অ্যাপয়েন্টমেন্টটা করে দিন। This will be from date of retirement till date of sanction. এখানে 10 September 2014. What is the date of retirement?
31st
আমার নাম
January
করছে
2007.
31st January 2007 সেম অর্ডার। আচ্ছা ওই ফ্যাক্ট একটু বলে দিই। He retired as head teacher from Hirapur Primary School, post Parasia, district Bankura, on and from 31st January to 2007. বাকিটা সেম। ট্রেজারি অফিসে টাকা জমা করেছে ওটা 10 সেপ্টেম্বর 2014 আর 10 সেপ্টেম্বর থেকে আসবে।
Only one Indian is praying for. Since no one appeared, my lord,
since
kindly, my lord,
ওটা করে দিন। State is unrepresented.
my lord, since
State is unrepresented.
22. 22. My lord, 22.
Oh,
No problem.
okay.
Phone
Learned
number.
advocate for the petition gives the matter to the discretion of the court. Hello. Disposed of. Thank you, sir.
My lord, I give this my application. The petition is seeking relief, my lord, for refund of awarded amount. As per settled law laid down by the my lord on Supreme Court by Rafiq Mercy case. State of Punjab versus Rafiq Mercy. So here in this case, my lord, the petition was the
My lord, in this matter, Mr. Ranjan Saha is appearing for DPSC Paschim Medinipur. He is engaged in courtroom number 37. My lord, kindly make it not
I
to.
paying for a similar judge. His name may be recorded. My lord, paragraph number 2, my lord, kindly see. My lord, petition was the headmaster of Bhagavantapur, Sushi Bhusham, Nimno Bunyadi Vidyalaya, my lord, who retired from service 31st day of October 2020. Well, thereafter, my lord, District Primary Council, my lord, directed the petitioner to deposit the amount, my lord, by letter date number 24/9/2021, which is at page number, my lord, 11 of the writ petition.
এটা 22 চলছে না 23
23.
নাম্বারটা ভুল হচ্ছে দেখো তো 560 here is 19560
Yes. 19560.
ভুলে যাক এই বছর প্যারা 2টা মিল ছিল না।
My lord, paragraph number 2, I have stated, my lord, the petitioner was the headmaster in Bhagavantapur, Sushibhusham Nimno Bunyadi Vidyalaya, who retired from service on and from 31st of November, October 2020. My lord, thereafter, my lord, since my lord, he has retired, but District Primary Council directed to, my lord, refund that amount 1,10,223. But since my lord, pension has not granted, petitioner has been compelled to deposit that amount, page 12. By your treasury chalan, my lord, the amount is there, my lord, 1,10,223. My lord, date is, my lord, here. কত তারিখে পেমেন্ট করলো? My lord, 28th day of September 2021, amount was paid. Refunded, my lord, by treasury chalan.
4th October.
Well, here, my lord, no, 28th day of September 2021.
Yes.
28th day of September. You also got it. Thereafter, my lord, after the payment is made, the pension was granted, my lord, page 14 of the page 14. On the 31st day of December 2021. My lord, even my lord, the Supreme Court, my lord, in the Rafiq Mercy's case, my lord, if they cannot, my lord, claim any refund of the, my lord, wrong fixation of pay, but my lord, it is, my lord, petition was compelled to deposit that amount.
So was it not necessary in the payment order to mention that there is overdrawal?
Nothing is there, but in the letter, on the first letter, my lord, by the District Primary School Council, on page 11, I am reading that সংসদ সভাপতি ভারপ্রাপ্ত অনুমতিকে জানা যে বেতন বাবদ গৃহীত অতিরিক্ত মোট 1,10,223 টাকা ট্রেজারি চালান মারফত সংসদ তহবিলে জমা দিয়ে এই চালানের কপি সংসদে আবার বিশ্ববিদ্যালয় পরিদর্শক দপ্তরে জমা দেওয়ার জন্য বলা হলো। It is there.
But it's not mentioned in the payment order.
No. But when the treasury challenge is there, that amount has been, my lord, deposited by the petitioner.
Lordship, this is my instruction, Lordship. According to the government order 181 SCB dated 8/10/2009, Lordship.
But this is the judgment, traffic bus. A serials of judgment was delivered by the one coordinated bench.
Lordship,
That
it is a government order and it is not demolished, Lordship. It is still in operation. According to that, Lordship, in case the employee opts for benefit on the date of entitlement, he or she will get one increment on that date, but he or she will not be entitled to next annual increment on the next 1st July unless he or she completes 6 months of service. In other words, if the date of entitlement falls during 1st July to 1st January, the employee, after having the benefit of one additional increment on the date of entitlement, will get annual increment on the next 1st July. But if the date of entitlement falls during 2nd January to 30th June, the employee, after having the benefit of one additional increment, will not be entitled to the annual increment on 1st July of the same year. He or she will, however,
When was
get the annual increment on the 1st July of the next year.
When was the fixation made? When was the fixation made?
Lordship, kindly see the instruction, Lordship.
It is the
That claim after retirement, this bar as per Supreme Court judgment. Nothing is one.
Lordship, I will file, Lordship, report in form of affidavit. I will annex the government order, Lordship, and it is still in operation. Lordship, para 4, Lordship. He has already received 10 years of benefit, and thereafter again he again receives excess of.
In 2010. In 2010, he retired on 2020. Right. So 10 years.
PPO is already issued, Lordship, on 30th 12/2021.
That is upon deposit of that amount. But this has not been indicated. This overdrawal was never indicated when there was a fixation of pay and the benefit of 10 years was extended to the petitioner in the year 2009.
Lordship.
So 11 years.
Lordship, I will file report. How the fixation
My
is
lord,
done.
according to me, also my lord delivered the order in terms of the traffic versus judgment.
Let them.
Well, I have several order I have brought.
And what about the judgment of the Honorable Supreme Court? You say that GO is still valid.
আপনি রেডিও আসেননি?
আছে, কপি আছে।
এই দেখুন ট্রাফিক বলছি, দেখেছেন আপনি? জাজমেন্টটা পড়েছেন আপনি? এটা পড়ুন ভালো করে। কি কোড করেছে?
Again, after he has retired, to when this letter has been issued, after 5 years of his retirement, the report has been given. The letter has been issued on when? Later,
my lord, after retirement, page 11, 24th of September 2021, after retirement.
That is also 1 year.
1 year. Is indicated wrong fixation of pay. Like I have no fault. I have enjoyed no grievance before retirement. After retirement, which is bar, as of Supreme Court judgment let down by the in case of malor traffic mercy.
Yes, madam. Affidavit of service filed on behalf of the petitioner, nearing affidavit of service টা
Well, affidavit
taken on-
service we filed one.
taken on record. By the present writ petition, the petitioner seeks for a refund of the sixth direction upon the respondent authorities to refund the overdrawn amount of rupees 1,10,223 together with interest at the rate of 18% per annum. The petitioner contends that he retired from service as headmaster in Bhagavantapur,
Mala, I am reading.
Shashibhushan Nimna Bunyadi Vidyalaya on 31st October 2020. After such retirement, when the petitioner sought for release of pension and other retiral benefits, the District Primary School Council, VDA letter dated 24th September 2021, asked the petitioner to deposit overdrawn amount of rupees 1,10,223 through Treasury in favor of District Primary School Council. In order to get pension, the petitioner deposited the aforesaid overdrawn amount on 28 September 2021. The authorities under the law ought not to have directed the petitioner to deposit the overdrawn amount. Hence, this challenging such action of the respondent authorities, the petitioner has preferred the present writ petition. Mr. So-and-so, learned advocate appearing for the petitioner, submits that, relying on the decision of Honorable Supreme Court in State of Punjab and others versus Rafiq Masi, Whitewasher and others, reported in 2015, Volume 4, SCC 334, submits that the authority, it is impermissible in law to recover the overdrawn amount from the employee after his retirement. He also places reliance on a coordinate decision of a coordinate bench of this court in Y. Rajeshwari versus State of West Bengal, WPS 6804 of 2024. On the contrary, learned advocate for the state, impermissible. He seeks for appropriate direction upon the who will disburse this amount.
Well, respondent number 6 will make payment. This authority has received that amount.
Director.
No, Treasury Officer, Ghatal.
Both. No?
It is within zone of the territory of the petitioner's school.
But in the other order, director has also been.
No problem.
2 and
Two responded two. No
2
problem.
and 6. On the contrary, learned advocate for the state submits that as per the existing Geo 181-AC within bracket capital B dated 8th October 2009. The petitioner is not entitled to refund of the overdrawn amount. She files report furnished by respondent number 3, District Inspector of Schools Primary Education, Paschim Medinipur, dated 27th August 2025, which is taken on record. The only issue which falls for consideration is whether the respondent authorities were justified to direct the petitioner to deposit the overdrawn amount or not. In this regard, it would be apposite to reproduce the relevant portion of the directions in Rafiq Masi Supra. এই 18টা কোট করে দেবেন। হ্যাঁ 18 এখানে করা আছে নিতে পারেন। In view of the above, this court is of the view that the petitioner is entitled to the relief as prayed for. Accordingly, concerned director, respondent number 2, Director of Pension, Provident Fund and Group in the Government of West Bengal, and also the concerned Treasury Officer, respond number 6, are directed to release the said amount of rupees 1,10223 together with interest at the rate of 8% per annum in favor of the petitioner from 28th September 2021 till date of payment. Stop. Such payment is to be made within a period of 8 weeks from date of communication of this order. Learned advocate for the petitioner is directed to communicate this order to respond number 2 and 6 for necessary compliance. With the aforesaid direction, the writ petition being number WPA 19560 of 2025 stands disposed of.
Instead of 24th, my lord, my mistake it is say 28th. But it is 24th, it will be. 24th day of September 2021, the date of payment.
24th?
4th day of September. Page 11, page 3. My lord, paragraph number 3.
No, I have allowed from the date of deposit of the amount. Date of deposit of the amount is 28.
All right, man, no problem.
Accountant.
Oh, no problem. No problem. No problem. I'm grateful to you.
Thank you.
But till the date of payment.
Till the date of payment.
I'm grateful.
এই ওখানে কি দিয়ে দেওয়া আছে অল্পের সাইডে পরে কি কন্টিনিউ করবে আবার এটা না তো ঠিক আছে রাখো
অর্ডারটা কি ছিল ওদেরকে কপি করতে রিটেন নোটস ওদের আমরা একটা দিয়ে দিই ওরা কত অ্যাপ্লিকেশনটা ফাইল করেছিল কনভার্টের যে নাম্বারটা কত G6 G3 যেটা আগে তো
My lord, I am appearing for the
petitioner in this matter, the executor, my lord. My lord, I have filed, I'm ready with my written notes of argument. On the last occasion, my lord had asked me to file my written notes. My lord, I have indicated the three judgments, the relevant paragraph numbers, and the paragraphs from the affidavit in support of caveat, where an adverse title is being set up, or an adverse interest in respect of the title is being set up, and
But
it is for my lord to consider.
he says that he is not challenging the
No, no,
title
when
of
I
the.
submit my
My lord, in that case, my lord, may that be recorded, because there are certain statements made which have not been undone as of yet. If they want to, if those statements are left, then or no clarification is given in respect of those statements, then I am entitled to this discharge. If they wish to may change, modify, alter those statements, then or say that they do not wish to, by affidavit say that they do not wish to proceed with that, then my lord, I completely leave it to my lord. My only issue is once they raise that objection or set up a title which is adverse, then they come under the purview of the exception.
Then he submitted on the last day that the caveator is not challenging the title of the testatrix.
My lord, that may be recorded. He may file an affidavit to that effect and state that I will not come in the way.
my lord, my respectful submission would be, my lord, where I have challenged.
Then we have to see if it is
where I have challenged, referred.
My lord, I have indicated.
They have referred, my lord, few
I have
lines in some
recorded
paragraphs.
your submission on the last day.
Yes. I have not challenged. It is
Then what
recorded in my lord's order.
Then what prevents you to file an affidavit to that effect?
I have in my written notes of argument, I have already submitted.
You have submitted written
Yes.
notes.
Well, written notes is not an affidavit. He can file an affidavit to that effect, and that can be done. That is the easier way around, my lord. One page affidavit.
How long?
I fail to understand from what context they are assuming that I have challenged.
My lord, I've already indicated the
Kindly
paragraph
have a look-
numbers.
Kindly have a look to my written argument, written notes of argument. Second page, first para. At the outset, it is most humbly submitted that the caveator has not challenged the title of the testatrix in any manner whatsoever in his pleadings up till now.
Then
And what he is abruptly saying, referring some, my lord, lines without reading the total, my lord, affidavit in support of the caveat. The harmonious construction has to be done. Harmoniously, my lord, he has to read. Each and every paragraph, my lord, I have shown it is my mother's property. I said I did not challenge the, my lord, the title of the degree of the compromise degree by which the property was devolved to my mother. I accepted that. I have even realized that. For what purpose I would file an? He will ask and I will file.
My lord will kindly see.
decide whether
Just indicate one thing. My lord will kindly see paragraph 7, page 5, paragraph 7F, if I may place. His categorical statements are that Chhaya Roy Chaudhary, whether my mother Chhaya Roy Chaudhary was a necessary party in the partition suit or not, under the Mitakshara school of law. However, she opted for guardianship of the caveator, herein who was the minor at that point of time. The Mitakshara school of law under Hindu succession, she was allotted this particular property on the basis of the compromise deed. So that one, it is a mention of allotment. Second, his contention is only as the guardian of the minor, I was given the testator was given the right. And third, that whether she was a party, necessary party or not, is also questionable. So these 3 points are there. Similarly, they have been harping on the Mitakshara school of law at paragraph 7B, and also they have indicated that at paragraph 7G, that on account of the residential premises being shifted where her dwelling unit was, since that was being shifted, this particular property was allotted to her. Continuously the word used is allotted. My lord, if this clarification is given by my lord's order, by his affidavit in any manner tomorrow, so that this question is not left at large again, then this question need not be decided in trial. It can be closed once and for all. That is my submission, my lord.
My lord, in partition suit, my lord, allotment is there. In partition suit, share property would be allotted to the parties. This is the language. Picking up some words, my lord, for what purpose I have used, I will not certainly disclose at that time. But my lord will find in every paragraph, my lord, I have referred in earlier occasions, several occasions, at her premises.
Application done. Application done.
Unnecessarily, my lord, they are wasting my lord's precious judicial time. Why they are afraid of proving the will in testamentary suit?
And this is not an issue which is necessary for
Because, my
proving the
lord,
will.
may I submit, my lord, section rule 28 of the original side rules. Following that rule, they have accepted my caveatable right and filed GA3. So, even if I take that application, when they have filed that application on affidavit, saying that this should be converted as this proceeding should be converted as testamentary suit, they have accepted my caveatable interest. Then thereafter they are filing this application. Whether they have withdrawn this application, no, I will not. I will not go file this. Continue with that application. They have now stopped from their conduct by filing GA3, and thereafter filing one or another application GA6, saying that I have not caveatable interest since I have challenged. I could have understood that he should have filed this application because the son has caveatable interest. There is no doubt. So on the basis, my lord, they have filed GA3 for converting, my lord, under Rule 28 of the chapter 35, for converting the probate proceedings into testamentary suit. Now, in the year 2022. And thereafter, in 2024, 2 years after, they are filing this application. How this application is maintainable? Because they have accepted my contention and filing the by affidavit filed this application seeking an order from this court for converting the probate application into the testamentary suit. So,
GA3.
And now they are seeking I will file an affidavit.
My lord, it is in the list, my lord. When I had started my argument, I had indicated that I do not dispute they have caveatable interest, but they cannot don two hats at the same time. This was my argument. My lord, our notes are there. We have argued, re-argued, replied, re-replied. My lord will kindly consider and give necessary directions, my lord. Much obliged, my lord.
Written notes of argument filed on behalf of the petitioner as well as the opposite party. Caveator is taken on record. Hearing is concluded and the decision, judgment is reserved. All the judgments have been given. That judgment in.
My lord, it was supplied with my lord's officers. My lord, I will supply another copy if required. My junior will supply a copy, my lord.
My lord, I said, my lord, those judgment is not applicable in my case because I have not challenged the title. Grateful, my lord. Well, important.
My application for removal of the receiver on behalf of some of the defendants, I had concluded my arguments, my lord, and the plaintiff had also concluded. Well, the receiver today is to, my lord, make submissions on behalf of the receiver. After my learned senior friend concludes, I'll give reply in respect of the submissions made by the plaintiff as well as the receiver.
Who is for the plaintiff?
Plaintiff Mr. Ratul Das had appeared on the last occasion. It was just there.
कागज
Lord, unfortunately, my Lord, I have to appear for the receiver in a matter in which the grand old man, having been appointed as a receiver way back in 1981, 87, 81. That কবে অর্ডারটা হয়েছিল 81 তো বলতে পারছিস না 81 না কবে 86 আমরা from 86 today we are in the year 2025. So my lord, his appointment has been sought to be challenged way back in 2023 by way of this application. After nearly 37 years, by the substituted heirs for the respondent numbers, legal heirs of the original defendant number 2. On grounds, my lord, which I would dare to submit for lordships, are not only without any basis whatsoever, but is a feeble attempt to win away from your lordships the entire factum of the case, even though as a receiver I am not interested in the either way which side the court will go into, whether in the plaintiff side or the defendant side. As an officer of a court, it is my sacred duty to your lordships, my client's sacred duty, that he should uphold the magistrate dignity of the court and the office which is sworn to perform pursuant to lordship's orders to act as a receiver in the suit. And I'll seek to demonstrate from the report which I filed that nothing of remote nature has happened, warranting, my lord, your lordship to interfere in the appointment of the receiver. But with a caveat which I will submit to your lordships, the receiver is not hankering for the post. He would like to leave with dignity to your lordship so direct. There is no charge of any misdemeanor on his part for the last 30, 40 years, or conflict of interest which they have miserably failed to demonstrate to your lordships, which is their foundation of their of the application. Number one, before I read the report which has been filed by the receiver, I would like to place certain paragraphs from the application filed by the defendant number 2, the legal heirs of the defendant number 2, original defendant number 2, which is, my lord, RA number 5. There are two things before your lordship takes away, took your eye, take your lordship before the issues. One, that in a case for removal of a person from its office, the allegation charging with misdemeanor or whatever charges are against him should be there at the very first front. In this application, I will demonstrate to your lordships, and then after we file a report, my learned friend comes up with fresh set of allegations in the reply. which we have been unable to controvert with because you are not given the opportunity. I'll show you lordship now. This is the application for, so lordship when it comes to the, lordship will kindly permit me, my learned junior, read because of my eyesight. If they are going to see properly, lordship will kindly hold my junior. The action. Now lordship will see the prayer portion first. Begins at page 80. There's B and C.
B, my lord. Leave be granted to serve a copy of the instant application upon the present receiver, namely.
That has been done, so my lord, I am lordship will see B.
Namely, C. Milon Sarkar, also known as C. Prayer C, my lord, an order be passed discharging the receiver, Milon Sarkar, with a direction upon him to hand over the possession of the said property and also documents and paper in connection with the said property to your petitioner number 2A to 2H.
Yes. So, my lord, these are the original substituted heirs of the defendant number 2, original defendant number 2. Now, my lord, will see that in the application of paragraph 1, 2, 3, he sets out the payers made in the suit. And then he goes back. My lord, I'll invite your lordship to paragraph 7.
By an order dated May 20, 1987, this Honorable Court was pleased to appoint one C. Ashok Kumar Mitra as receiver in terms of the prayer A of the said application made by the plaintiff. A copy of the said order and sergeant. Subsequently, on May 26, 1987, the said receiver, that is the C. Ashok Kumar Mitra, took possession of the entirety of the said property. In this regard, a copy of the said minutes drawn by the learned receiver and also the photographs taken by him May 26, 1987 are collectively annexed.
Yes.
I shall first go to the background of the facts of the case. There was a land measuring approximately 66 decibels, which is approximately 2 acres of land, in a prime place in Shivamogga, Siliguri. My lord, that was the subject matter of a suit between the plaintiff and the defendant. Now, my lord, plaintiff filed suit, then with an application, he got an order from the court. I don't have the original order, but I've annexed a copy of the order in my report.
Report to the
Which is, you will see a report of the receiver, which
is annexed to the application. Annexed to the application.
No, annexed to my report, receiver's report. There's a
filed by the
filed on
August 2022.
August 2022.
My lord, my learned senior friend is referring to the affidavit in opposition filed by the receiver.
Yes.
Data to sir,
Opposition.
number. Yes, my lord. It is the affidavit in opposition filed by the receiver. Okay.
Page number? This is annexure.
Page number 11.
Yes.
My lord, Mr. Ashok Kumar Mitra, the wanted receiver of the property. The present receiver was not the original receiver. My lord, receiver took possession of the property, and then, my lord, he resigned. And thereafter, the present receiver was reappointed in lieu and in place of the original receiver, Mr. Ashok Kumar Mitra. And there was thereafter a portion of a land, the original 66 decimals of land, amounting to 31 decimals, which was the subject matter of a sale. And similar of the original 66 decimals, subsequently after filing of the suit, 31 decimals were sold pursuant to the orders of the court. That I'll show to your lordships. And the court thereafter appointed the present receiver as the receiver over the remaining portion of 34 decimals. Similar, there is a point which may be taken up by my learned friend or may have been taken by the learned friend. I was not present to your lordships, that the entire subject matter of the land is 66 decimals. It is not so. Presently, I am the receiver over 35 decimals of land, which is butted, pounded, and walled by a brick built wall for the last 38 to 39 years, without any trespassers being allowed therein. Now, you will see thereafter at page number 30, and it's a B, you will see another order passed by the then court. My junior will not read this. These are the two orders which are the basis of which brought.
31 decimals যেটা বিক্রি হয়েছিল সেই
Yes,
order. The petitioner are added, my lord, the petitioners are added as party respondent. The order dated 26th April 1988 is modified and or varied as follows. It is recorded that the petitioner have purchased 31 decimal of land as more fully described in Annexure I to the petition. Out of 66 decimal of land being the subject matter of the suit, and the petitioners are presently the sole and absolute owner of the said 31 decimal of land more fully described in Annexure I to the petition, and it is stated on behalf of the plaintiff that he has agreed to purchase from the petitioner, and the petitioner have agreed to sell to the plaintiff the said plot of land as herein stated at the aggregated price of rupees 39,000, and that the plaintiff and the petitioner have further agreed that the sale of the said plot of land shall be made in favor of the plaintiff and or his nominee or nominees in accordance with the two draft deeds of the convents, both being Annexure K to the petition. It is stated on behalf of the petitioners that the statement made on behalf of the plaintiff and recorded herein is true and correct. Accordingly, it is ordered that the petitioner do sell the plaintiff and a nominee or nominees the said plot of land more fully described in the Annexure I to the petition and aggregate price of 39,000 in accordance with the two draft deed of convents being Annexure K to the petition. In that view of the matter, the receiver already appointed over the said plot of land is discharged, and he will make over possession of the said plot of land to the plaintiffs and or his nominee or nominee, in whose favor the convents in respect of the said plot of lands will be executed. That said receiver will be, however, carry out the earlier order dated 20th May 1987 passed for the construction of the boundary wall in respect of the balance 35 decimals of the land after excluding the said plot of land being the 31 decimal. The suit will be continued only in respect of the aforesaid balance 35 decimal of land. The order of injunction passed on 26th April 1988 against the petitioner restrain them from selling the said plot of land is vacated, and they are directed to sell that dispose of the same in terms of this other order. The petitioner will give undertaking to this court to carry out this order, and such undertaking is recorded and accepted by this court. The application accordingly disposed of.
Presently now, of the original 66 decimals of land, 31 decimals of land was the subject matter of sale by virtue of this order, and that has not been challenged. And today, 35 decimals of land is the subject matter of the present suit, for which my client has been appointed as a receiver, continuing as a receiver. And the receiver was permitted receiver's remuneration of 100 gems per month. Original direction was that the receiver to pay a remuneration of 100 gems per month, which unfortunately till date has not been paid to my fund. Even the rest continue the rest as usual. You have to bear that in mind as well. Now, my lord, coming back to the application, then also may I bring your lordship page number paragraph number 5. Actually, read this application because the application, your lordship will see that from a bare perusal of the application, your lordship will be aghast to find that there is no case made out for removal of the receiver. Your lordship will kindly come to paragraph 8 at page 6.
6.
6 of the original application. 4.
Subsequently, on May 26, 1987, the said receiver Ashok Kumar Mitra took possession of the entirety of the said property. In this regard, the copy of the minutes drawn by the learned receiver is also photocopy taken by him on 26, 1987, collectively marked as at. It is humbly, next paragraph. It is humbly submitted that this honorable court was misled into passing of the aforesaid order of appointment of receiver inasmuch as a prayer was not maintainable in view of absence of any relief in the instant suit with regard to the possession of the said property. It is also has to be borne in mind that such an application was moved and aforesaid order was passed without any notice to the original defendant number 2 since deceased.
These are issues which goes to the subject matter of the issue. Nothing to do with the removal of the receiver. So, my lord, now you will see how they develop an application for removal of the receiver. And I'll tell you, Lordship, why this attempt has been made. Your Lordship,
Next, my lord, para 10. Thus, pursuant to the aforesaid order dated May 20, 1987, the original deceased defendant number 2, who was the producer in interest of your petitioner, was dispossessed from the said property by the learned receiver, despite the original deceased defendant number 2 being the owner of the.
may I pause here for a moment. Your Lordship, see what is the language of the pleadings. The original defendant was dispossessed by the receiver. The attitude is to somehow malign the receiver.
Yes.
But how can a receiver, without being permitted by an order of a court, take over possession of a property which is the subject matter of a suit, and that too, my predecessor in office, Mr. Ashok Mitra, not me, who had taken possession. So keep that in mind.
Next, furthermore, in the facts and circumstances of the instant case, neither the plaintiff nor the defendant number 1 had any right to remove the owner of the said property from the possession of the said property, since the original deceased defendant number 2 was in possession of the said property by virtue of the ownership. Next, the instant suit is essentially a suit for specific performance of an alleged contract for sale of the said property executed by and between the plaintiff and the defendant number 1. The original deceased defendant number 2 admittedly was never a party to the said alleged contract. Next, it is only in the highly unlikely event of the suit being deceased a degree in favor of the plaintiff that the plaintiff will derive a right to sue for possession of the said property, and that too in a court having territorial jurisdiction over the said property. As such, in the instant suit, the plaintiff could not have sought for an order which would have. পড়া হয়ে গেছে 30. Next, para 13. In view of the aforesaid, it is humbly submitted that an order be passed directing the learned receiver to hand over possession of the suit property to your petitioner by discharging the receiver.
So, so the first ground of discharge is purely and simply based on the actual order that may be passed in a decree passed by the court. Nothing to do with the conduct of the receiver. First, in paragraph 13, for the first time it says 100% after discharging the receiver. The first one. Now, as you will see the paragraph 14, 59, not acceptable or accepts. So, as we now straight away come to
21.
paragraph 21. I will not trouble losses with the entire
21, my lord, it is humbly submitted that the appointment of
23. Paragraph 23. Paragraph 2.
paragraph 20, my lord, it is pertinent to mention that in the beginning of June 1987, that is barely a week after possession of the said property was taken by the receiver, the personnel of the receiver was charged from the Ashok Kumar Mitra to one Milon Sarkar, an advocate based in Jalpaiguri, from a paper publication made in Uttar Bango Sambat on December 3rd, 1987, and the instance of the incoming receiver. It would entirely appear that on June 2, 1987, this Honorable Court was pleased to change the personnel of the receiver. It would further appear from the such paper publication that this Honorable Court had entirely directed the incoming receiver to construct a boundary wall around the said property for protecting the such property. Next, minor para 21, it is humbly submitted that the appointment of the receiver by the order dated May 20, 1987 is itself bad and not maintainable, since appointment of the receiver was not in aid of any of the relief sought for by the plaintiff in the instant suit. Under such circumstances, the receiver presently in possession of the said property ought to be discharged, and possession of the said suit property should be returned to your petitioner.
Tomorrow, the round number 2. Nothing to do with the conduct of the receiver. Till paragraph 21 in the application.
Yes.
Now, the Lordship will see paragraph 23 onwards, my lord, and you will Lordship to straight away to paragraph 24.
Yes.
24, my lord, in any event, the present receiver has acted.
For that.
My lord, kindly see para 23, my lord. There is a genuine conflict of interest in the present receiver continuing to act as an officer of this honorable court is holding on to the possession of the said property, specifically that since it is manifestly clear that the said receiver is also a director in a company wherein the plaintiff is also director. Furthermore, such fact was neither intimate or informed to your petitioner or this honorable court by present receiver or the plaintiff, and the same tantamount to willful suppression of the material fact.
I should go,
Next.
go ahead. I should go ahead and read your Lordship why the question of directorship comes. Your Lordship will read paragraph 22 first.
22.
22 at page 11. Then the entire sequence of the facts will come to your Lordships.
Your petitioner have recently discovered that the receiver, that is Milon Sarkar, also known as Milon Krishna Sarkar, is a director of the Terraiti Company Limited. The plaintiff, that is the Rajendra Khanode, is also director in the said Terraiti Company Limited, OBG3 Company Private Limited, and Terrai Infrastructure Private Limited. In this regard, the relevant documents enlisting the receiver and the plaintiff to the director in the name of the companies annexed here to and marked as.
So, my lord, your Lordship now is perhaps understood the basis on which the line of attack of my learned friend with regard to the continuity of the present receiver in the post as such is there and has been sought to be challenged. In 2014 around, I'll appraise your Lordship. Your Lordship is aware of the fact that the Few Companies Act 2013 makes it obligatory for any company, public limited company, to appoint independent director. Independent director. Now, my lord, the present plaintiff was a director in respect of one regarded office. It was a company in which the receiver in the year 2014, so Malad 14 and 87, after 27 years, he was called upon to act as an independent director in respect of a company which is not a party in the proceedings.
Yes.
See, paragraph 22. They do not disclose the date on which they have come to learn. They say very recently. So no specific date has been given, disclosed by them. And I'll tell you what is why. Because after filing of this petition, and after we filed our opposition to that, they went before the security municipality and put copies under the 2005 Act, and they sought to improvise over their case. In an affidavit in reply by filing additional facts. This is the extent which they have gone to. So, Malad, in paragraph 22, they say very recently they have come to learn now as an independent director, and an admission has been made also by them that the receiver was not called upon to sign any document which he cannot do because he's a non-executive director. Cannot sign any checks, nothing. He will have to go and as per the company said, he will have to do certain acts which are mandatory for an independent director to hold office. Now, that was way back in 2014. They do not tell why they do not come in the year 2014 and apprise you the receiver that you are not entitled to, or you should have brought it to the notice of the court. There is no order passed by any court of law that during the continuance of my office, I cannot act as the independent director in respect of a company which is not a subject, which is not a plaintiff or a defendant in the suit.
One of the plaintiff is a director.
One of the plaintiff may be a director, but being a director and the company being a juristic entity, Lordship will be well aware of the fact that the director is an officer of the company. Company is a juristic person. And the company is not a party in the proceedings. Neither the plaintiff nor the defendant.
Yes.
And the receiver has been appointed as a director in the suit, with the company, which is not a party in the suit. Neither the plaintiff nor the defendant. Maybe one of the directors of the company may be a plaintiff in the suit. But ask the question to myself, would it be a reason for me to demit my office on this ground, especially after 27 years? Assuming I do so. Then everything, I will not be able to do anything in my capacity as a professional person.
Okay.
Having thus gone to the section of making a conflict, now Allah will see paragraph 24. The only ground If they have sought to make against me, then I should see at paragraph 24.
At paragraph 24, in any event, the present receiver has acted beyond the scope of the order dated May 20, 1987, and the same would be evident from the following facts. Number one, Ajit Kumar Agarwal, Terra IT Company Limited, Obijit Company Private Limited, and Terra Infrastructure Private Limited has jointly submitted an application on July 7, 2021 to the Siliguri Jalpaiguri Development Authority, Siliguri, to grant of land use compatibility certificate under section 46 of the West Bengal Town and County Planning and Development Act 1979, along with the site plan, by amalgamating the said property which is in possession of the receiver, and other plots of land belonging to the Terra IT Company Limited and the Terra Infrastructure Private Limited by suppressing the fact relating to the pending litigation with respect to the said property. It is needless to mention that the present receiver, being the director of the Terra IT Company Limited, is deemed to have knowledge of such application being made entirely on behalf of the said company. Such an application was made after the receiver became a director of the Terra IT Company Limited. Your petitioner has come to know of such facts from a letter dated March 14, 2022, issued by the Siliguri Jalpaiguri Development Authority in reply to an application made by your petitioner number 2D under the Right to Information Act 2005. Your petitioner have also obtained copies of the land use compatibility certificate and site plan submitted by the aforesaid person before the Siliguri Jalpaiguri Development Authority. In this regard, a copy of the application made by the petitioner and such. Next, my lord, B. Moreover, the said Ajit Agarwal, Terra IT Company Limited, Obijit Terra IT Company Limited, and Terra Infrastructure Private Limited appear to have jointly submitted a building plan to the Siliguri Municipal Corporation, Siliguri, on June 26, 2021 for its sanction and approval, which is pending approval in the office of the Commissioner, Siliguri Municipal Corporation. Your petitioner have come to know of such fact on the basis of the letter dated 3/2022 issued by the Siliguri Municipal Corporation pursuant to the application made under Act 2005 by your petition number 2D on December 10, 2021.
So the four persons, three companies and one individual, not parties in the proceeding. The suit, none of them are parties in the suit. So, if three or four or maybe more than that number of third parties make an application with regard to and before a survey authority with regard to the subject matter of the suit, being 35 decimals of land, is there a bar in law to prevent them from doing so long as the receiver illegally does not hand over possession of the same to them? Is there a case made out by my learned friend that the receiver has handed over possession to them? No, that is not the case.
Yes.
সাইন করে রিসিভার কোথাও সাইন করেছে সেটাও দেখো।
They have admitted that the receiver has never signed anything document also. Not a single document also. They admit in their reply also. So, my lord, assuming for argument's sake,
Yes.
assuming for argument's sake, my lord, let us say, my lord, this is the High Court. Now, my lord, let's say 5 of us, we jointly make an application for the registered High Court, registered, seeking to file a conveyance for sale of this High Court. And the Honorable Chief Justice hands over possession. It is possible. It is not possible. Similarly, the case made out to show that there is a conflict of interest is spurious and, to say the least, my lord, is an act of desperation. To malign the receiver, who has got 45 years of practice here and being the senior most lawyer in the circuit bench and one of the oldest lawyers in civil.
Yes.
My lord, so there is no allegation that receiver has handed over the land of possession. There is no allegation now. And there is no allegation that the receiver has signed any document for the statutory authority also, or has given him power to the other person to sign on behalf of the receiver. I'll show your lordship the admission made by the council. Now, my lord, lordship, when it comes to paragraph, then C, my lord. Count number C and B.
And see, my lord, it is pertinent to submit that the said Ajit Kumar Agarwal, Terraiti Company Limited, Abhijit Company Limited, and the Terra Infrastructure Private Limited entered into a joint agreement to promote and develop such shopping mall on the said property. And for that purpose, the director of the above named companies passed a resolution and executed power of attorney and submitted the same to the Siliguri Municipal Corporation, Siliguri, for plan approval. The same would appears from the land use and compatibility certificate issued on October 5, 2021 by the Siliguri Jalpaiguri compatibility certificate and aforesaid site plans. It would appears from the paper publication made by the receiver as stated herein above that this honorable court has directed construction of the boundary wall around the said property. However, the said wall has been demolished at the behest of Rajendra Kanodia, Ajit Kumar Agarwal, Sitaram Sharma, Kamal Kishore, Biani and Arun Tharat, and all directors of the Terraiti Company, Obijitri Company, Terra Infrastructure Limited, which is evidenced by the Bhaktinagar Police Station case number 1528 dated December 3, 2021 under section 448, 188, 427 and 34 of the Indian Penal Code.
My lord, a new case has been made out that walls have been broken. The boundary wall engulfing the subject 35 decimals of land has been broken. Receiver has not taken any steps. Receiver has not informed this court. Nothing. My lord, they have been unable to show one document also. One document. That when they know that the land is the subject matter of a suit under the possession of a receiver, the first thing, if a party is agreed by an action of a third party, is to approach the receiver. And the receiver would have filed a suit, a GD before the appropriate law enforcing authority. At least that is what we have been taught. That when a property is under the aegis of a receiver, one can go straight away to the police authorities or law enforcing authorities, ignoring the receiver or not informing the receiver.
Yes.
And then say, make an allegation against the receiver. Why do you do this? And where is the final report filed by the Bodhinagar police station? When I asked the question to myself, have they annexed a copy of the final report?
Now, what is the stage of the investigation, right?
It's for them to say. I don't know. I have not a party in proceedings. If they have filed a GD, they say there is an FIR. Then it is for them to apprise and satisfy your lordships. I'm not a party. Had I been the complainant, I certainly would have been able to assist your lordships. I'm not a complainant there. And they have never written to me until I come to learn in this application for the first time in 2022 when they filed this application that such a thing has happened.
But then being a part of a management of a Terai tea company against the other directors, this GD has been lodged and a specific case has been initiated. The receiver, being one of the directors, did not have the knowledge that against the subject matter.
One of the question is, have they said they had the opportunity to make a case against the receiver that he was also a party in round number C or D? They specifically named. Have they been able to show that the receiver was there in the proceedings or the meeting where this allegation was made? Making a bold statement in the wilderness. Whether a lordship will give credence to such false statements. I can understand there is a plausible case, that there is a case where I have overcome my authority. I'm saying I means receiver has spent his authority and he has given his mandate to go and do whatever she wants to do. But that is not a case made out here. Had I been in the shoes of my management, I would have perhaps drafted this application in a completely different format. But as you will see, 3 companies and an individual jointly have entered into an agreement. The company individual directors do not make any. Why? Otherwise, Ajit Kumar Gawal has been named as an individual person. And the company as juristic persons are the. So therefore the company and who is to be representing the company, which are also well aware of, the person appointed by the company to represent the company. Now, where is the allegation that the receiver, being a independent director, the question is, it's an independent director, he had on his own violation accepted that these things have been happening. My knowledge is not sufficient. They will have to prove for your lordships that there was an overt act on my part. Not a covert, but an overt act.
But then having knowledge that a wall has been demolished.
No, I'm saying just the opposite. Let the lordships go and appoint some special officer today itself. See whether there is a demolition or not.
No, the fact is that there is an allegation of demolition of a wall.
No.
By the order of the court, the wall was made, boundary wall was given as against 35 decimals of land.
No.
Now, let me put it like this, that there is an allegation against the directors of a company. One of the directors is also the receiver. He says that I am not aware of any demolition. No charge sheet has been filed. My question is, how come he is not aware? If he is aware, what is the steps taken by the receiver to protect the property?
Very simple answer. There was no demolition. Rather, I have on the next day I'll show your lordship the report, which will say just the reverse. The report which I will.
My lord, may I only to in answer, my lord, there is no demolition. There was because this wall was constructed in 1987. The wall was not in a proper condition in 1922. In 2022, on the basis of which it was required to be re-raised or properly raised. At that stage, the height of the wall was raised. So, my lord, in November 2021, the defendants come up and lodge a complaint saying that the wall has been demolished. But subsequently, again they file a complaint, and my lord will see their application at page 121. The allegation is that the height of the wall is illegally raised up to 10 feet approximately. So that is their allegation. Initially, my lord, the height of the wall was not as much, but now the height of the wall has been raised. And my
Okay.
lord, this is their allegation as on 16th of February 2022. So, my lord, no construction work, no permission sought, nothing has been done of that sort in respect of the particular property. And my lord, the plaintiff is only a individual. He is a director in one of the companies where the receiver also became a director subsequently.
My companion lordship.
Kindly. Yes. But now he is saying that in 2022, there is a complaint which says that for raising of the wall, steps have been taken. Raising of the boundary wall. There was not so demolition. No demolition. Now, why in the affidavit in opposition, why that complaint has not been annexed to your affidavit in opposition?
My lord, the affidavit, the complaint is annexed to Mr. Mukherjee's application. It is
Okay.
there in the application. It has been dealt by both by the receiver and me. My lord, I am also assailing the particular complaint because it is not proper. My lord, I am not defending the personnel of the receiver, but the order should stay.
Devashish Kundul and its senior advocate appearing for the receiver due to possibly hearing could not be concluded. Release this matter. না নেক্সট আমি জলপাইগুড়ি থাকবো 17 থেকে 28-এ ফিরবো ডিসেম্বরের ফার্স্ট উইকে ফার্স্ট থার্সডেতে যেরকম আছে fourth December.
My lord, may we file our written notes, my lord, because we are at the conclusion. May we file our written notes, my lord?
No, without he being concluding the.
My lord, my submissions are concluded. As and when Mr. Kundu concludes, I shall.
On 4th December.
Lord, before my lord rises, Lord,
May I make one request, my lord? 4th December, my lord has kept it. If I could request my lord to take it up after 8, I'll just indicate the ground. My learned junior is a happy occasion for which he can't attend the court. It will be after 8th, 9th, and ever.
Mr. Kundu. Mr. Kundu. He submits for making it after 8th, so 11th December.
Lord,
Yes.
Lord, may I trouble your lordship once, my lord, before rising, Lord?
That review matter.
Item number 5, Lord, the section 5 application. Lord, it appeared one day at the top of the list. Affidavits complete in the section 5. May it appear on the next Thursday, my lord, at the top only for the application. If my lord decides against me, then it will be the end of the road. If it is in my favor, they will file opposition in the review petition. Item number 5, my lord, if it comes up, my lord, at the top on next Thursday, my lord.
Difficulties.
Only 70 days delay. So
70.
they have 70. They have filed an opposition. They wanted to take time, Lord. Everything is over now. So I'm not arguing anything on merit, Lord. Whatever they have said, I'll show your lordships. If we could, I'm very convinced that I'll be able to convince your lordships. 13th, Lord, if it is appear at the top.
4th December, top of it. Mr. Chakraborty, on 4th December, top.
Now, what I was just saying for your lordship's kind, if the section 5 is done, the time for filing the affidavit in the main review, they could utilize.
Sir,
that
I will not be here. No, there is a circuit bench on 17th. From 17th onwards.
13th, if we can get 5 minutes time.
Next week, not possible.
Only 5 minutes time.
After he come back on 4th December.
At the top.
I take to have a review.
My lord may pass an order, my lord, to that effect today, my lord. If it, since my junior is here, my lord, he is for the other side.
Who is on the other side?
Mr. Chakraborty comes up with this prayer every week. For the item number 4 is an election petition. I am not even praying for upgradation of that.
Because he knows nothing will happen.
One limit is they come.
No, in review use the opposite party.
For the opposite party.
Or 150
on
crore.
the joint prayer of the parties.
My lord, kindly do not record my prayer. That is not my prayer for 4th December on top.
I am
I am
praying, Lord,
opposing that.
because he is enjoying 70 days delay. He wanted to use an affidavit.
4th December note করুন 4th December top এ আসবে
My lord, may pass an order, my lord, on my mentioning, Lord. On my mentioning, my lord, may pass. On my mentioning, my lord, may pass an order, my lord, on 4th. Please. On my mentioning, my lord, may pass some order, my lord, keeping it on 4th at the top. Otherwise, my lord, yes, on that.
Sitting at 4:35.
On that, my lord, on that.
Where were you at 3:30?
Lord, I was here only, my lord. I was waiting. This matter was going on. Only my lord may pass an order. He is here. That
On the prayer of Mr. Srijit Chakraborty, learned advocate for the applicant.
Yes,
Please don't oppose such.
Yes.
Release this matter on 4th December at the top.
I'm so grateful to you.
Yes, Mr.
Lordship rises, but I have a very small prayer. But I know it is a very, very problematic. But only thing, Lord, this matter regarding the receiver thing in the 10 old post receipt. Only thing, Lord, what the problem is because of court order, Lord, the receiver's hands are stayed with regard to touching the money. Now the staff, class 4 staff, that is why, because they need to be paid their salaries. So
which matter? Which one?
The Charushila matter,
Charushila matter, my lord. Precarious circumstances is prevailing
Kindly.
at the intervention of this receiver.
I don't know three.
Only thing, my lord, only thing I am
I don't know three.
Only thing I am
পড়িয়ে দাও, হ্যাঁ 11 December তো 4th রিভিউর পর রাখো দেখি
Lordship, they fix the date.
4th রিভিউর পরে দেখা যাক কি হয় রিভিউ
all the advocates of the building have come out
on 4th December after the review matter is made.
Only thing, my lord, all the advocates.
The building is suffering the anarchy of the receiver, my lord.
Upon me as I was appearing on behalf of
with full due respect to your lordship,
She doesn't have any locus.
To your lordship, that is, I am submitting, my lord, that I have not served, but that does not mean I have disobeyed your lordship.
You will not
But
comply with
I
the
shall
order.
demonstrate.
Yes, my lord, because she has not been able to show her locus
Has rejected it.
before any of the honorable judges.
The Lordship will hear that.
Calling for anybody to come. Lord, she didn't come.
Why
Now
should she come? Because
and
I'm
she is
already
nobody.
there.
Why should I?
She is nobody, starting from honorable justice.
Hand over a copy. These are not the disputes. Hand over a copy to her.
My lord, she has no locus to appear, my lord. Kindly appreciate. She is in hand in glove with the receiver.
In number 10, have agreed on an interim appointment of Ranjan Roy, who is an applicant.
This is fraudulently
She
obtained.
is in. Every time they will come and shout.
Yes, fraudulently obtained. Mr. My application is pending.
Honorable.
That modification is required.
Division bench presided over by Justice Manta has already directed.
Thank you.
My lord.
On 4th December. Yes.
My lord, will come back.
After 4:30, you want to do the matter.
There are provisions.
Sir, এবার করুন ম্যাটার কি বলবো বলতো
কেটে দাও ফোন করছি